Good morning, everyone. Today is October 2nd, 2019. This is a regular meeting of the members of the State Liquor Authority being held in Albany. Present today are Chairman Bradley, Commissioner Ford, Commissioner Fay, and Deputy Commissioner Licensing Roberts, Counsel to the Authority Mayor Hoff, Secretary to the Authority Donahue, and Associate Attorney Ferring. The next meetings of the Authority will be 10/7. That's going to be a special meeting, which we'll talk about in a second. 10/23. 11/6 and 11/20. Now, there is a 3-week break between today and the next regular meeting. We're going to call items first in Buffalo, although right now there's nothing in Buffalo. Then in Albany, then in New York City. And the items in Albany that we expect appearances in New York City, we're going to hold until then. As your item is called, please approach the podium, whether it's here, or Buffalo, or New York City, and put your name on the record. Please speak clearly into the microphones because everything's being recorded for posterity. A couple of reminders. There is a special meeting, as I noted, on October 7th, next Monday, regarding the proposed third-party advisory. Any submissions should have already been received. Don't bother sending anything in now. It won't be included in the record. The members for that meeting will be present in New York City, but we will have video conferencing to Albany and Buffalo. Also, another reminder that the chairman is hosting a meeting for attorneys and non-attorneys who represent applicants and licensees in New York City on the 22nd. Just for clarification, there seems to be some confusion. This is not for licensees themselves, just for the attorneys and non-attorneys who appear before us on the applications or in disciplinary matters. Chairman, do you have anything?
Yeah, just to clarify, the focus of that meeting is obviously the preparation of the applications and many of the issues that we're seeing in reviewing the applications. So while anyone is welcome, it's a public meeting. I don't want to waste anybody's time because if you're not doing this for a living, there's really no point in coming because you won't really be interested in what we're talking about. And I also want to announce that we have a new counsel to the authority, Gary Meyerhoff, who's sitting to my left. Gary comes from a 25-year career at a major international law firm. He was a litigation partner, and we're glad to have him. I also want to thank Mark Ferring, who's been acting counsel for the past 7 months, I believe, Mark, who did a great job in that role for the second time since I've been here. But we're glad to have Gary here, and I'm sure that many of the attorneys are going to want to speak and meet with him over the next coming months, and you obviously can contact him for that. He's going to be based in New York City, but he will be up in Albany periodically, as he has lawyers in both places as well as Buffalo. So we're glad to have him.
We'll be repeating all these announcements at 11 o'clock when we go to New York City. All right, we have no items right now in Buffalo. We have one in Albany. And then, remember, I have a bunch of defaults. You can fill the time doing those until we go to New York. All right, the first item in Albany is 1916. Rockland Spirits. Oh, I'm sorry. I take that back. My bad. It is 1927. Which is Caribbean Fast Casual Inc.
Good morning, Chairman. Good morning, Commissioners. This is Robert Romano on behalf of the client. We are here today with a conditional no contest plea. I brought Sean and Deborah Guidraj, who are the principals of the licensed premise. As you can see by a submitted letter from the Office of the Mayor, both the Mayor and the police chief are recommending that you do keep this premise open. I would also add that...
which would not be happening without that.
I totally understand that, which is why I was very pleased to receive that letter. I would also like to point out that in order to get that letter, they went through considerable expense to assure that there would be no more reoccurrences of any issues that occurred previously of similar kind. They've installed state-of-the-art two large security systems, I believe. 16 cameras. They've increased...
Well, see, and I get the camera thing, and everybody wants cameras, but the cameras only allow us to get evidence after things happen. And it's obvious here that things are happening.
Right.
And what are they doing to avoid that?
They've increased the lighting in the parking lot.
distance, license,
I mean, what's happening? I mean, 5 months the police were called there and 911 called 16 times.
And they haven't been called since May.
But what was going on?
Sean, could you explain why? I mean, I know that a lot of these incidents did occur outside of the premise. There one where they're walking from the parking lot across the street.
But why are they coming? What's going on that's leading to the violence?
I think it was the 24-hour gas station. They're all cutting through our parking lot. So we have guys outside in the parking lot now that are, you can't walk through our parking lot. You can't just cut through, and people been hanging out in the back of the parking lot. So we have a guy just on the outside on the weekend when we're open to make sure nobody's hanging out in our parking lot. They're either in the establishment or on their way home in their car.
And all of these incidents, I believe, did not happen. None of these incidents, I believe, happened within the premise, actually.
Yeah, none of it.
It was all on the perimeter. So they did extra lighting, what kind of lighting?
Stadium lighting throughout the building, all around, front, both sides, front and back.
And they had
16 high def camera.
What's the store? What you call it? A gas station? Are they selling alcohol at the gas station? Is that a mini mart?
Beer.
What's the name of that?
Speedway. They're 24 hours, 7 days a week.
And they've spent in the range, I believe, close to $15,000 already, monies which they can ill afford to do all this, to assure there wouldn't be any reoccurrences.
Did they put a fence up like they between the? I see there's no fence between them and the speedway.
No, there's no fence.
Why?
Because Speedway and our parking lot, that's where we push the snow during the winter months.
But they're walking right. If you're telling me it's coming from Speedway, they're walking right out of Speedway parking lot right into your parking lot. If there's a fence there, they can't do that. He's out there the whole time you're open.
We're open, yes, sir. And that really stemmed the problem. That and the lighting. We met with the chief, the police. Letting him know that there's cars in the park in Speedway, like a car meet, all these cars meet up, and they're drinking beer out there. So they kind of clamped down on that. So that helped the situation as well.
And I have
Must
to
have
say,
been a tremendous turnaround from 4 or 5
Yeah,
months
there's
ago.
a bunch of underage that are hanging out at Speedway parking lot, drinking beer, because they can't get in my establishment. So we let the police know that as well. I think police are going away now. So I haven't seen those cars lately. So I think that kind of helped our issue as well.
and I have to say, I've known the Boot Garages for 4 years now, I think?
4 years.
4 years, and they're truly good people that are trying.
Okay.
All right.
We ready to vote?
Yes.
Well, is it a vote?
No, it's a no contest. Straight no
It's a vote-
contest.
It's a vote on what the penalty's going to be.
Right. Oh, then you're right.
So I'll take care of it. Commissioner Cannon?
Thank you for all the effort. I hope that the situation will improve so on that can pass.
I was at 5,000.
Well, I was at 10. So, thank you.
I guess it's 10.
Are you going to change to 10 then?
Then I'll change it to 10.
Okay.
We don't have to.
I was going to say it's a matter of procedure. So.
It doesn't. I mean, with 2 votes at 10, we're at 10.
I just want to know, it makes it easier for me. That's all.
Yeah.
Thank you.
Thank you very much. Thank you. Thank you.
Okay, we're going to go through some defaults now while we're waiting for the next matters either in Albany or in New York City. First item is 1910. The agenda sheet indicates it's a not guilty. It's actually a default out here.
I'm at revoke.
Come on. Can we get a name stop and location stop?
Sure. It's going to be anyway, well, at least for 2 years.
Right.
All right. Commissioner Ford?
Revoke and bond as well. Or
There's no bond.
Revoke for the record, yes.
All right. All right, the next item I have then is 1911, 444 North Ave report.
I'm at cancel and bond.
This was about 2 years ago.
What is this time, 1909?
1911.
Oh, I got the wrong one.
It's an availing, the license has expired.
The premises is no longer active. All right. Here's 1911.
Yeah. Okay, go ahead. Where you at?
Cancel and bond.
Yeah, cancel and bond.
Next item is 1913, the Hills Restaurant and Bar, Inc.
I'm at 2,000.
I'm guessing this, Alan Rick is gonna be making another request for reconsideration. These always default for some reason.
Right.
Security guard. Yeah, 2000.
2000.
Next one is 1915, OL Enterprise, Inc.
I'm at 10,000, but this is of significant concern. New license, then a default. Not happy. This is already the second time in this year. But I'm at 10,000.
Records. Yeah, books and records, this is the second time. 7,500. You said 10,000?
Yep,
I was at 12.
I'll go to 12.
12.
Next item I have is 1921, 19 Stanton Restaurant, LLC.
This one is a default. I think they said that if the lawyers call. I'm at 2,000. I mean, they did say that they sent a letter saying that they want to submit a CNC, so should we wait?
No. Because it was delivered. I mean, whether it's a lawyer's fault or their fault, it was.
Well, it's Levy.
I mean, if you want it, we can.
I'm at 2,000. I don't think it changes the outcome.
2000.
Yeah, they've had failed to comply noise. This is like the third time, so 2000.
Next item, 1922, Deli Y Taqueria La Familia Corp.
I'm at 5,000.
I'll go with 5,000 as well.
5,000.
All right, the next one, 1944 to 1945, Praga Lounge NYC, Inc.
I've done some further investigation of this. PD definitely suggests that we do not allow this to continue, and so I'm at cancel and bond.
That was pretty much my assessment too, that questioning if this place should even be open. So I'm a canceling bond as well.
Cancel and bond. We have nothing coming in Buffalo,
Nothing
I mean,
yet.
today
They're
there's-
keeping the feed open just in case anybody shows up late.
but we have nothing on the calendar.
Nothing right now. And we have one item, Albany left, but the applicant, it's a Rockland County case, the opposition's here, but the applicant might show up in New York. All right, we have one more default, 1964, Cafe Guana, Inc.
I'm at cancel for the record. This is for
Just cancel when you cancel a bond claim, because last time you licensed to take the bond claim.
cancel and bond. Okay.
It's already canceled.
Okay, say that again, Tom?
Okay, so last time, it was a canceling bond claim,
Oh, and they paid
and they
instead.
paid it rather than get the bond claim.
Yes, a cancel and bond.
Cancel bond.
All right, with that, I am out of defaults. You want to take a...
Was anybody signed in and
The only thing, I don't know, if anybody else is showing up on those, they wouldn't be here till 11.
but if they're enforcement matters, it wouldn't matter.
I don't have the list yet.
All right, we can do the summary. Is the lawyer here? Or the dean?
Yeah, Margaret is here.
All right, so we have a request. This is item 1966A. It's a request from counsel's office for a emergency summary order of suspension regarding High Flying Birds, Inc.
Hi, Margarita.
Margarita Marsico on behalf of counsel's office. I'm requesting that the Board of Commissioners issue...
Hold on 1 second. Can we turn that up?
Yeah.
Okay, go ahead.
Counsel's office is here before you requesting that you issue an emergency order of suspension as to a licensed premise located at 7814 Roosevelt Avenue in Jamaica, Queens, by the name of High Flying Birds Incorporated. We're requesting that you do this because on September 23rd of 2019, there was a multi-stabbing incident involving a 20-year-old and a 16-year-old. The 20-year-old was pronounced likely to die at the scene by an EMS lieutenant. And this was directly as a result of an incident that occurred inside and spilled outside of the licensed premise. In addition, there have been numerous fire life safety violations that were revealed in an inspection conducted by Investigator Stravali post-stabbing. And the last reason we're requesting you shut this place down is because this premise is being operated by a person who is unauthorized by us. And they're also non-bona fide. They're supposed to be operating as a restaurant, but they don't serve any food and have no food available. So just on that basis alone, the fact that they're a non-functioning restaurant would be sufficient under the current law to cancel the license, notwithstanding all the other safety violations and public threats. So as reported to us by the police department, I spoke to Police Officer Cash, who was the first responding officer. On September 23rd at approximately 4:05 in the morning, he received a 911 call of a multiple stabbing to a premise about 6 blocks away from the licensed premise. He canvassed the area, didn't see anyone, but at that point, various other officers who were on foot posts, etc., found the victims directly in front of the licensed premise. The 20-year-old male was on the ground. He was stabbed multiple times. And there was a 16-year-old female who was with him who also was
She's
injured.
16?
Yes. The Officer Cash got a little bit of the story from the victims. They said that there had been a fight inside, that the 16-year-old is actually the girlfriend of the 20-year-old. She actually came to his aid inside the bar. She got involved in this brawl, and that's how she got herself injured, because she got involved in the bar brawl. The police officer Cash said he looked through the gate inside the premise. It was closed. He could see through the cracks in between. It was completely dark. He didn't see any people inside because he was trying to go in to see if there's further evidence. He was desperate to find out who it was that was involved in the incident. He kept talking to the girls, various bystanders, to try to determine who it was that committed the stabbing. He says that approximately 20 to 25 minutes later, 2 men walked up and said, "Oh, we're the owners of this place. We heard that an incident had occurred," and then they opened the door. Officer Cash and various police bosses entered the licensed premise. They observed the bucket of blood inside the licensed premise. There were droplets of blood on the floor. They were told by an individual named Freddie that he had bought half the premise for $250,000 with his partner, who still remains on the liquor license. But the partner who's actually on the license is out of the country, I believe somewhere in Latin America. There's some discrepancy whether it was Ecuador or Colombia, one of those countries. So he was not around. Unfortunately for us, though, as the regulator, we were told that Mr. Wilson Quiseno, the man who's abroad, is actually the one who's operating the place and is supervising. But he was not there. We just had Freddie there. In addition, as I said, they're not operating as a restaurant. After this incident, Investigator Stravali did a full inspection. He detected over 40 violations. One of the troubling ones is that they have no public assembly permit, and one of these people, either Freddie or another person named Carlos, who calls himself a manager, told Investigator Stravali that they just don't have a public assembly permit. And I think you could see from yourself from Investigator Stravali's inspection chart that he always does, that there were a myriad of violations. They had no books and records to prove where they're purchasing their liquor from. They had all sorts of issues with the fire alarms, with the emergency lights. The interesting thing that they discovered during this post-stabbing inspection was that the rear door to the premise, that the panic bar was off the door. So they asked, why is the panic bar off the door? And they were told that on the night of the stabbing, everything was locked up, and some girls panicked, and they ran through the rear corridor, and broke down that rear door because they couldn't open it. The door was illegally locked. So apparently this is how some of these patrons fled at the time that they shut everything down when the stabbing occurred. I've spoken to Sergeant Arnold, who's very involved in patrolling this area at night because, sometimes with this precincts, things are a little bit scattered. The special ops lieutenant may not work during the midnight tour. This commanding officer may not be as familiar with what's going on at certain times of night. But this Sergeant Arnold told us that he's very involved and he's been very involved in monitoring this premise, and he's noticed recently there's definitely been an uptick in incidents that the licensee has been uncooperative when he's gotten calls of assault by security guards. He's been told that they have no video when they should have video. So
Did they call 911 when this incident on the 23rd happened?
They did not call 911.
And did it happen inside the bar?
It happened inside the bar. The detective.
So they removed the victims to the street and still didn't call 911?
Well, it looks like the victims during the fight were adrenaline rush. They didn't even know they'd been stabbed. And the 20-year-old who almost died was stabbed multiple times. He didn't even realize he was stabbed. He was actually, the detective said in the video, you could see him standing and walking outside before he collapses. So.
Well, did they kick them out?
It looks like the female assailant that stabbed, because the one female was stabbed by a female, and then the male was apparently stabbed by other males. The female who stabbed the female was apparently ejected, and she tried to get back in. But it's not clear who was ejected when or what. But it's very clear that they didn't call 911 immediately. They didn't call 911.
Okay, I think we're set.
Yeah.
Ready to vote?
Oh, I have one more question. So it wasn't clear in what you were saying. Freddie, whoever he is, acknowledged that he paid $250,000 to become a partner, and is it safe to say he's not on the liquor license?
He's not on the liquor license, and he said this repeatedly to the detective, to the police officers, and to the investigator. He said it like 3 or 4 times that he's the owner. He has no shame about saying that, which shows how clueless he is, and even admitting that to law enforcement. So
Okay, okay, thank you.
Yeah.
You ready to vote then?
Yes.
Commissioner Fan.
This situation and fact pattern perhaps is exactly why we have the ABC law, so this is extremely disturbing with multiple sale to minors, a lack of control of the licensed premise, clear lack of supervision, non-bona fide, not acting as a restaurant. Lots of building code violations. It's essentially a fire trap where patrons really shouldn't be going into, and then more importantly, as the chairman pointed out, is the availing. And so this case is really a clear situation where the licensee shows complete disregard for this authority and also the existence of the ABC laws. And so for that, I find that there is an imminent threat to public health, safety, and welfare, and vote to summarily suspend this license.
Commissioner Ford.
This place was licensed back in 2013. They paid $24,000 in fines in the past few years. This latest round of incidents, stabbing of underage patrons, attempts by the staff, obviously, to clean up and conceal the evidence of that inside. They're not functioning as a restaurant. Previous sales to minor, 138 911 calls, including 13 where an ambulance was requested. Owner seems to be in absence. Gambling devices, focal point for police, no public assembly permits, no workers' compensation insurance, numerous safety violations. I think they got quite the record substantiating an emergency summary order of suspension, so I vote to suspend.
I'm going to vote to suspend too. It's clearly a danger to the public health, safety, and welfare, and it's in an area that is extremely problematic, and we get a lot of complaints about for this exact type of activity. So I vote to summarily suspend.
Thank
We can just get a brief recess. I need to check which case is coming up next. All right, we are back on the record after a brief recess. The next item here in Albany is 1912 BKUK 10 Corp. Come on up.
Good morning, everyone.
Who's who?
State your name for the record, please. Both of you.
Blessing Kuka,
I'm sorry,
principal of PKK 10.
Claudio Fernandez.
Who's who?
He's the principal, I'm the agent.
So, you guys shut for 4 months, open back up again, your license expired and you never sent the renewal in?
So I would like to thank everyone for our consideration, and we were closed down for construction for a few months, and then
And I assume we didn't get your license when you were closed down in safekeeping, you didn't give it to us.
So we had a manager there that failed to send it back to the liquor authority.
Well, it's not the manager's fault.
No, but I just wanted to explain that and why that,
Okay.
that oversight.
So then you did the renovations, you opened back up again and nobody saw that the thing expired?
well, the manager and people that were managing the stuff, they misplaced the license and
So from March 31st, from you reopened on May 24th, you didn't put the license back up?
So we had an expediter that would receive all the mail and would alert us to any renewals and things of that nature.
Well, the mail is also sent to the premises.
No, it is, but she's the one that recovers the mail and makes everything happen. So she, unfortunately, also failed to submit the renewal in a timely fashion. And
But
that's
you're
why-
not answering my question.
I apologize.
The question was, when he reopened, where was the license?
So it was misplaced. It was all.
So it never went back up.
It never went back on. And unfortunately, that was an oversight that was a big miss. The manager failed to inform the principal of this, and things started to continue as normal, operating as normal. And then when it was discovered, obviously the 30-day notice was submitted, and it was promptly submitted for renewal. A fine was issued of $500 for the renewal, as well as an approval was sent, and then subsequent to that, a disapproval of the license was sent.
Explain that to me, Adam.
Do you want to?
What's the?
So you're saying a late renewal went out. We sent out a late renewal in July. We disapproved on July 12th.
We have confirmation that it was approved, and we had submitted the $500, which was over.
What confirmation do you have?
May I go get it out of there?
Yeah. The statements he gave our investigator contradict what you just told me.
Which investigator, I'm sorry?
Well, he says that he knew the license expired when he reopened in May.
He did?
That's what we were told.
no,
That is not accurate.
that's not.
I apologize. Give me one
So
second.
what are these facts here? That then he knew it was licensed, it was expired, and that he immediately processed the renewal by submitting a 30-day notice to the community board.
That is correct. So upon...
So he did know that it was expired or not?
No, he did not know. Upon immediately finding out that it was
I'm
expired.
checking to see if there's any report.
But I guess
He just asked you a whole line of questioning where he asked you if you knew that it was expired and you just said no.
So
Like when you reopened, that's what
So-
that was.
So when we reopened, we did not know that it was expired at that time. The manager, again, had misplaced the license. So because it didn't go back
I
up,
thought it was in the box.
it was in the box, but it was not found in the box. And then subsequent to that, the expediter who also collects the mail failed to notify him that it was up for renewal.
Well, so at a minimum, when he sent the 30-day notice of the renewal, which had long expired. The license had long expired.
Correct.
Did he stop selling alcohol when he sent that 30-day notice?
I think
I
at that
think the
time,
answer
yes.
is no.
I'm not certain about that because I don't know what the dates are.
Well, ask him.
We had indicated no, which is why we denied the renewal.
That he kept selling.
Right.
So,
Because he was still selling without a valid license.
And that's because our guys went in there and bought.
We are old friends. How many restaurants do you own in Manhattan?
Serenata.
Because you were on the CB. Okay.
Yes.
Well, that's the other aspect is you do have multiple licenses. So the fact that you didn't know kind of is not really credible.
Your Honor, that place, that particular place was when I moved in 2 years ago. I was paying a high amount of rent, and then I notified the landlord that I'm leaving in end of 2019, which is an end of January. So then we worked out with the rent. She reduced the rent to me, so I decided to do some construction in the place. And then the manager that was working in there misplaced it, but we did the construction for 2-3 months. So by the time that we went back in after the construction, he misplaced the license and stuff. And then I managed all the other licenses. I always give community board notice and stuff. I never
So how
have
many
problems with
licenses
this
do you have?
particular license. I never have any issue.
How many
with it.
licenses do you have?
I have 5 licenses.
Okay.
I never have any issue in this particular place. The only thing is we just missed.
So this is the problem. This happens all the time. But what doesn't happen all the time is when people come to realize it and they keep serving after they realize it, which is what you admitted to our investigator you did. That's the problem here, is that you compounded this mistake by making more. And that's why the thing got denied. Now, I'm going to let them decide since do you eat here?
Well, sir, again, we meant obviously to do well, but in this
But
case,
you can't say that he
no,
didn't.
but I agree with you in one respect, but I would like you to understand from our perspective that because the manager failed to notify him, upon him realizing it, sure, it should have never been done. He was mistakenly told by the expediter, as soon as we submit this, you're good to go.
Yeah, but
And
he
she
owns
was-
5 restaurants.
I understand that. That makes sense.
This isn't like a neophyte. How long have you been in this business?
After I got told, when I went to the place, that day, when they told me about this, I haven't served. The place still open. I haven't served no bit of alcohol in there. After I got the ticket myself, I haven't sold any liquor.
But it shouldn't. That's the point. It shouldn't have come to that.
And we concede to that, and we totally apologize and ask for your understanding that this was a one-time event. The manager has been fired. The expediter is no longer employed or utilized by this principal here. And so we were hoping that you can give us the benefit of the doubt this one time, and we're giving you our assurance that the new team that we have in place won't allow this to ever.
Are your other
No, but
licenses?
it's not the team's responsibility.
No, I understand, but if we want to do a concerted effort that alongside of the community, the law enforcement
After
community.
they give me the fine, after they told me about it, it's been 3 months ago, I haven't served a bit of alcohol in there. I have been paying rent, $28,000 a month, which just reduced the rent for me. I haven't served any bit of alcohol.
But do you know what jeopardy you put yourself in? Do you have any clue? Because if we revoke this, you lose all the rest of it. You lose all your other restaurants.
We understand.
That's why I'm here.
Well, he clearly didn't when this was going on.
And like I said, sir, we concede to that.
All right, I guess we're ready.
All right.
All right, so are your other licenses clean? Have you had any issues with us?
This is the first one I
I was looking at it.
There's been history. There hasn't been on most of the locations since 2012, 2016, 17.
But what is it?
Let's see. Workers' comp violation.
Which in my mind is not paying attention to your business.
I was at Sorrento.
The same kind of stuff. All right, we're ready.
Ready to vote then? Commissioner Fan, So this is for reconsideration and then,
Of the renewal.
right, so first are you gonna grant reconsideration, and then if you do, what are you gonna do with the renewal?
Okay, I will go to grant reconsideration.
I'll vote to reconsider as well.
Same here.
And then so now it's before you're gonna vote on it or send it back to licensing, what do you want?
We can vote.
Commissioner Payne?
I mean, only because like really no incident happened, no one got hurt or anything, and look, we're in the same community, and so you know that this is a really good opportunity to change the way you deal with your businesses, and the community board is there to support you, and we're here to help. So really focus on it and talk to your lawyer and try to figure out what the rules are.
Thank you, Commissioner.
And with that, I will vote to remove the renewal and issue the license.
Commissioner Ford?
Are we here to assess any type of penalty?
That was already done.
Well, that's what I was going to ask. Have we charged?
Yeah, I looked, there was a late renewal done.
Did we charge them for serving without a license too?
No. They paid $500.
On the late renewal?
Yes.
Well, then email Joe and make sure it's charged with the.
Well,
Oh, you guys can do it. Okay. Mark, can you make sure that you guys get charged for serving without a license? Yeah. Okay.
So we're voting today to issue the
Renewal.
and this council is following up on the charge of serving without a license.
Correct.
Okay, so you'll be hearing from us again.
Yes, sir.
Yeah,
I understand.
Chairman Grab.
I'll vote to renew as well.
I'll vote to renew. Good luck.
Thank you. We're dismissed. Thank you very much.
Thank you for your time.
Have a great day.
I don't know when you hear about that. Don't go serve tonight. Wait till you. I don't know how long will that take.
It's about the weekend. I would by tomorrow. Probably.
Okay, so go call our office and you should be able to pick it up by tomorrow.
Thank you very much.
Thank you very much.
And we can go to 125th Street.
Yeah.
Thank you.
We'll do some disciplinaries that are signed in New York. I'll wait for licensing to show up. 1962, New York Products Distributors, Inc.
Leonard Fogelman, attorney for the licensee.
Michael Brennan, president of New York Products Distributors.
You have an offer in front of you for charges.
Can I take a moment with counsel?
There are brief recess to Carpenter Council. All right, we are back on the record on item 1962 after a brief conference with council.
Go ahead, Mr. Foden.
Oh, we have a offer of a $70,000 offer for the three charges. If you have any questions, we'll.
Yeah, I kind of want to know what he thought he was doing.
We hired a marketing company to sell on the internet for us. We
How'd you hire him? What do you mean you hired him? You paid him a salary?
No, we paid him commission.
My understanding was you were getting a commission.
In my wholesale business, I work on a dollar discount from all the major wholesalers. And when he came with all this marketing and all, I said I would work on the same dollar and give him commission above all the expenses that I incurred.
How much was the commission?
It varied by the product, how much it was sold for.
I'm not following you. You entered into an agreement with a company that ships small kegs of beer, correct?
It's 2-liter bottles.
And to do that, you allowed them to use your license to basically order kegs from a manufacturer.
No, sir, that's not correct. I ordered the kegs from the manufacturer. They were delivered to my warehouse. It was shipped to their warehouse where they had a warehouse permit. It was bottled into the
How'd they get to their warehouse?
my trucks.
Because when our investigators went into your warehouse, there were no kegs there.
It comes in every single day. We get 5 trailer loads a day, and whatever was their order, I would ship it over there, so it wouldn't be at my place more than a couple of hours as soon as the trucks were available.
So you never had any beer shipped directly to their warehouse?
No.
So there are warehouse receipts then for all those shipments you made to the warehouse?
Sure. Invoices. I have paid invoices. The beer was sold to me with my license. The beer was sold
Invoices from who?
from the breweries, from the wholesalers.
No. Do you have warehouse receipts for the kegs that you sent to that warehouse?
I have signed invoices.
That wasn't my question.
All right.
I have trucking invoices that I pay my driver.
I think you answered my question. Thank you.
All right. I don't have any other questions.
Are you ready to
I mean,
vote?
this is... The only reason I'm not going to try to take your license is because I've been asked not to, but I don't know why we wouldn't.
How long did this go on?
We started talking September 2017. It started very slow.
And this company has been in business 30 years without any prior violations, to the best of my knowledge.
Yeah, since 1994. So started September 2017. When did it stop?
When we stopped it.
Which was
August 2nd, 2019.
You said May?
That's
August 2nd.
August of 19.
We ready to vote then?
Yeah.
All right.
Wait, how come the visit was in February, but then you didn't stop until August?
The investigation was started in February.
But at a minimum, you got charged in June. You kept doing it after you were even charged?
Then that came up with a different Mr. Brennan, your Mr. Brennan, and we wrote to Mr. Brennan, and
We were going back and forth, and
So you kept doing this after we charged you?
my client wrote to Mr. Brennan, and I forwarded it to him, and it's my interpretation. He didn't ask me, but he continued to do this. He wrote, quote, "My interpretation was that when our offer was accepted, we would immediately stop doing business with Hopsy." So
That's not how it works.
When did he hire you?
Well, I'd have to see when I put in the
I don't know. What do you want to do?
yes.
Mr. Fogelman, they're discussing it. We ready to?
Yeah.
Commissioner Fan?
Mr. Fogelman, give me a reason why my vote should not be canceled in Vaughn.
Well, I think the main reason is a couple of reasons. Number one, he's been a good licensee for 30 years. Number two, he obviously was doing something wrong. He hadn't done anything wrong before. This was an availing situation as far as why he didn't stop doing this when the charges came out. He did not ask me. He was not under he was under the impression that he didn't have to, and he therefore continued doing this until I realized or was told that he was still selling to Hopsy, and then he immediately stopped, and we immediately told William Brennan that the activities with Hopsy had stopped.
No, I can't buy any of that. The only reason I'm not at cancel is because you've been in business since 1994. You have a clean record otherwise that we know of.
There's nothing. I just checked.
There's nothing. So
There's even going back to no, nothing at all.
yeah, but still, I mean, what you did is unallowable. I'm at 100,000, not 7. I'm at 100,000.
I'll go with 100.
Okay. So counter offer of 100,000.
Yes.
Okay.
Thank you very much.
Thank you.
Next item I have here is 1963 Manhattan Beer Distributors.
And Leonard Fogelman from Manhattan Beer. This is a charge for effectuating a corporate change prior to permission of the Liquor Authority. Corporate change was filed. It was 589 because of a disciplinary charge pending. The corporate change is now waiting to get approved, hopefully subject to whatever happens here and the acceptance of our offer.
Well, that's not really what happened, is it? There were 3 changes, and you only filed 1. There were 3 transactions, correct?
If you could refresh my recollection as to what the 3
I'm not going to refresh your recollection. It would be nice if you read the case before you came in. All right,
Ready to vote then?
Yes.
Okay, Commissioner Fan.
I'm at 35.
Commissioner Ford.
I was at 45, but I'll accept. I'll take 35.
35.
All right, counter offer of 35,000. Thank you.
Thank you.
All right, we got a couple more licensing. 1966 Guayacan Bar and Lounge Court. Excuse me if I mispronounced
Say
that.
the name number again, Tom?
1966. Somebody sign it? All right, let's try then.
Why can't we just do that? Who's
Well, yeah, I don't think there's another case.
Oh, all right.
Very short. 1943. 760 8th Avenue Rest Inc.
70 McGrath for the licensee.
So before you get going, let me withdraw charge 3 at council's request. Go ahead.
Thank you, Mr. Chairman. These are incidents where The licensee immediately took action. There was one punch thrown. They held the person. They called the police. The police came. They observed the person who was hit, and there's nothing much more that we can do in these situations. We immediately call the police, and especially with the one charge that was withdrawn was also we kept the person who was then arrested by the police. So the licensee tries to do everything that it possibly can and notifies the police immediately on an occasion.
What is this place, a restaurant?
Yeah.
It's a restaurant. Yes, it's a restaurant nightclub. The Copacabana.
I think they did everything that they could do to enact the responsibility. I would dismiss. I would dismiss the whole thing.
I have to letter of warning.
No, we gotta. Yeah, I'm not willing to dismiss it. What do you want to do?
I'll go with 2,000. But I mean,
I mean, we dismissed the third charge, so it's just the two charges. So I'll go 2,000.
2,000? 2,000.
You gotta have the record.
All right, $2,000.
Thank you.
All right, next item. 1885, Jacob and Kelly, Inc.
Thomas Burke. Thomas Burke for the licensee. Licensee is Mr. George Donison. Mr. Donison is here today. His problem was with his corporation, which was dissolved in 2012. He didn't realize that until this year when the SLA notified him in a notice of pleading that he was operating without an active corporation. He's been trying to pay off the back money and reactivate the corporation. This has been complicated by the fact that his mother is dying of cancer in Atlanta, Georgia, and he spends some money traveling back and forth every month to see her, and he's also paying for her experimental medical treatments. But he does have another business that he sold, and he will collect the funds from on November the 11th. And on November the 11th, he will be able to pay his back proceeds in full and reactivate his corporation. We asked that.
Why did the corporation get dissolved?
It was a tax issue, but we weren't aware that it was dissolved because I only just found this out when you guys sent me the letter, because over the course of the past multiple years, we've had unemployment insurance, we've had disability insurance, we've had an active what do you call it with the
taxes.
Tax ID. We've had an active tax ID. We've paid our 941s. Now, at one time, when anything come up when we were getting the insurance, through the state insurance fund or private funds, that our corporation wasn't active, so we had no idea. So this is an absolute dismay.
So it was inactive since 2012. How are you even filing sales tax receipts?
I filed them. I've had
without a corporation.
I don't know if state and tax would talk to each other as far as that's concerned.
Is the $200,000 you owe in taxes sales tax?
Yes, sir.
Well, you didn't file. That's why.
Well, we did file, but we didn't pay a lot of it. And the other thing is we've been back paying it recently, and even then they put us even for this. I actually have an offer in compromise that I won't be able to do because I want to settle this with you guys right away. The offer in compromise, which would reduce this in half practically, I have to negate because it takes about 8 months for that to happen, and I know you're not going to give me 8 months. So I'd rather go the other business, pay this, get my corporation active.
I mean, but there's no active corporation right now, right?
I have another corporation that if you allow me to do a liquor license transfer, I could do that. But
Whoa.
You can't do that.
Okay, I was just asking. I just have a. But
Are you open now?
Yes, sir. the thing is, I could have everything settled and cleaned.
He has paid $55,000 ever since he found out in May that the corporation was no longer active.
I get that, but we have a license out there that he apparently is operating that has no owner because the corporation has been dissolved.
He's been doing that since 2012.
I know.
But
Could he do it another month?
30 days, and I'll have this resolved.
That's outside.
The members got a brief, hold on. The members got a brief conference with council to discuss this. We are back.
By the way, everybody at the table knew it. It had nothing to do with my being an accountant.
We're back on the record after a brief conference with council regarding 1885 Jacob and Kelly Inc.
So we went outside because the name on this liquor license does not exist anymore, which means in our mind we can't let the license exist anymore. So what, and you shouldn't be selling because the corporation doesn't exist. What you can do is reapply under your new corporation, but we can't transfer a license from a corporation that is no longer an entity to another corporation that you just started because there's no one to transfer it from.
So it can't be a transfer, that has to be a new application.
Yes.
Is there any way?
Exist.
Is there any way I could have a postponement of 30 days to get this corporation active? I've already spoken to Albany about getting the corporation active, and all they want me to do is make the payment, and they'll reactivate the corporation for me. And I'm literally just waiting for the check to come in by November 11th, certified funds, and I'll be able to pay the entire fines and find me whatever.
The State Department's going to let you reactivate this corporation with it must have a $230,000 lien on it for sales tax.
180, actually. 180.
But that's a lien on the corporation. Why would they allow you to open it again?
We're going to
have.
See them doing it, they work out payment plans.
All right, well, I'll adjourn it for 30 days then to see what happens.
Thank you so much.
Thank you very much.
Thank you.
Hold on.
Yes, sir.
So hold over to
30 days isn't going to be enough.
To get the corporation going?
They're not going to get the check till November 11th.
Oh, then do it. What's the first meeting after that?
We have 11:20.
All right, do it till.
So all good with that? Holding over to 11:20. All right.
But if it's not active by then, we can't do it anymore.
Understood. It'll be active. Thank you.
It will be active. Thank you very much.
Would be too bad if it ends.
All right then, we're going to go back to Mr. Romano's matter, since it's now 11 o'clock. 1916, Rockland Spirits, Inc.
Morning, for Garrity, appearing on behalf of Irina Mushkilik.
Can you repeat your name? I'm sorry, I missed it.
Christopher Garrity, appearing on behalf of Irina Mushkilik and Rockland Spirits Inc.
And you are?
I am Robert Romano. I am here with Mr. Vikas Shah and Mr. Thomas, who are the proprietors of Crest Hill Liquors and North Main Liquor and Wine Corp., which are the two closest stores to the
Okay, let me stop. So we're going to let the opposition go first.
Let me just make sure. Is there anybody in opposition down in New York City?
No, there's no opposition.
Crest Hill and North Main?
Crest Hill and North Main. They're the closest north proposed premise. The opposing application is an approval for this location would not serve to the public benefit, convenience, or advantage. Crest Hill Liquors is located just over 310 feet away from the applicant's premise, and this minimal distance separating two stores under normal circumstances would almost certainly result in disapproval from both this or any other board. That being said, I do expect the applicant today to contend that this store would replace ZA Petroleum Incorporated, DBA Arenas Liquor Store, previously located just 110 feet from my client's, Mr. Shah's premise. Arenas Liquor Store had shuttered their store over a year ago. However, only recently...
Where's that?
That was Arenas is also on North Main. 298 North Main. 298 North Main.
And ZSA, correct? Petroleum?
Yes.
ZSA, right. ZA Petroleum. Also known as...
Two stores around there closed in the past year?
No,
That's what he just said. He said ZA Petroleum.
ZA is Arenas Liquor Store. It's the same.
Oh, it's the same.
It's a DBA. And
got it.
I'm referring to Arenas Liquor Store for a reason. The timing... That store was deemed abandoned only recently. And even though it was only recently abandoned, it had not been in operation for a year. And very apropos of what just occurred here in this room and with the teleconference, ZA Petroleum Incorporated had not been an active corporation in New York State, as far as I can tell, since October 28, 2009, which may account for at this point, to me, rumored tax implications that they're currently going through or had gone through.
You mean we issued the license when the corporation wasn't active?
No. The license was issued, I believe, in 2005.
Oh, it's just 15 here. Okay.
Okay. Now, the license was originally issued, and I cannot explain. I tried to find out why it was granted, but you were...
I was not his owner.
Right, so we couldn't find a reason that normally a store would never be, in my history, in my experience, a store this close would never be approved. But the timing is questionable to me, and I can't, even though if an arrangement were made, that's certainly nothing illegal or it is not prohibited by the authority, but I don't believe any arrangement was disclosed to the authority. Although the license issued to Arenas Liquor Store was recently declared abandoned, we have information and belief that it has been closed since September of 2018, over 1 year. As I mentioned, they've been closed for over a year. There may be tax and lottery issues that you understood that were the reasons that the store had not been operating. There is no question in our mind, and the record will show that the store had been closed for over a year. Prior to the closing, the location is in a rear of a gas station with poor visibility, minimal product availability, and did have low sales. Regardless of that, the closing of the store in 2018 would explain Mr. Shah's increased sales, which came about due to the fact that store closed. They picked up a portion of those increased sales. While the increase to the sales figures was measurable, the effect to the bottom line was not as dramatic. Increased advertising, promotional costs offset any significant increases in its net income. The gross sales numbers to the other surrounding stores, to the third and fourth, don't show any increases as far as we know. I couldn't find. I foiled the gross sales letters, but I did not get them. But in speaking to the owners, I was told the gross sales figures did not increase in any measurable way. The current existing stores adequately satisfy market demands. Every one of the premises carries a wide selection of product, including New York State manufactured wine and spirits. Public convenience and advantage is further served by free tastings, educational seminars, deliveries, personal service to customers, again, all offered by the currently existing neighboring stores. Further illustrating that the community would not benefit from the new stores, data indicating the population of Spring Valley remaining flat for the past 5 years, evidenced by a graph which I submitted to the authority. Those numbers, coupled with a decrease in household income and a poverty rate in the area of over 25%, diminish the likelihood of any quantifiable upturn in local commerce anytime soon. The standard criteria that this board usually uses when deciding new applications, the sales figures, location, saturation, population, product differentiation, would normally result in an immediate denial to this applicant given the close proximity of their proposed premise. However, in this case, you're faced with what appears at first glance to a replacement store, normally an easy proof for this board. This case, however, is differentiated from a usual replacement case. In this case, Irina's Liquor Store was so close to my client's store that this is an opportunity for the authority to clean up previously, as I call it, over-licensing. Additionally, it has been over a year since Irina's Liquor Store had been open to the public, and I would ask you to view this as a new location. After conducting a bit of research for this opposition argument today, I began to question possible unreported relationships between ZA Petroleum, DBA, Irina Liquor Store, Sloatsburg Wine, I gave you the serial number, and the current applicant's proposed premise. The timing of the closure of Irina's Liquor Store, this application's hearing, and the matching name between Irina's Liquor Store and the applicant principal may be nothing more than a coincidence, but it does appear that Ms. Mascalic may have other interests and involvement with the business, aside from that of an assistant manager that has not been disclosed to this authority. With the current application, Ms. Irina Mascalic declares she was the assistant manager for Irina's Liquor Store from July 2004 through September 2018. The original application filing date for Irina's Liquor Store was March 25th, 2005. Which begs the question as to why she claimed to have no ownership in the business, would be hired as an assistant manager more than 8 months prior to the filing date of the store, and subsequently even longer when considering the effective opening date. Additional findings also suggest to me that Ms. Mascalic may have non-reported availing ownership in Irina's Liquor Store. According to an ABC News report from September 5th, 2012, in which an attempted robbery at the store was reported, quote, the Spring Valley store Mascalic and her sister have owned for 6 years was empty. End quote. The story clearly identifies Ms. Mascalic as the owner of the liquor store. And I want to point out, even if she was not the owner of the liquor store, by representing herself to the liquor store, since I think speaks volumes about her character and attributes. According to the authorities database, this applicant principal is the only Mascalic to have applied to the authority for a license. With the application today at hand, she claims to be the assistant manager in 2012. Again, there's been no disclosure of ownership by her representative to the authority for this or any other New York premise in New York State. Now, with regard to another store, Sloatsburg Wine. During the fall of 2017, there was a fair amount of local press and promotion given to the opening of a new store in Rockland County. According to LoHud.com, as well as SloatsburgVillage.com, Olga Lukashik and her sister, Ms. Mascalic, took on an existing store from Keith Reardon. The sisters gave multiple media interviews and made Facebook posts at the time. I submitted an exhibit in which both were identified to be owners and operators of the new premise. In fact, they're quoted in the November 21st, 2007 Journal News, stating that, quote, owning their own store was our dream come true. My belief that Ms. Mascalic has an undisclosed interest in Sloatsburg Wine is further buoyed by this October 2018 post from her personal Facebook page. The post is an image of a poster entitled Sloatsburg Wine 1 Year Anniversary, and this is her personal Facebook page in which she directly asks her Facebook visitors to support our dream and our charity event. This presumably for the celebration of the first anniversary of Sloatsburg Wines, as well as support for a local charity, a food pantry. Again, it's on her personal Facebook page. It is my understanding that the applicant principal before you today has not disclosed any ownership of or employment by Sloatsburg Wine Incorporated to the authority. Any ownership or revenue sharing interest by Ms. Moskalik in Sloatsburg Wine would obviously preclude her from obtaining a second L license today. Any non-disclosure of interest or role as an employee would bring into question her character and fitness, whether or not her character and fitness rise to a level adequate to hold a license. It is clear from a review of her personal questionnaire, which was completed in April of this year, she omitted having any involvement with Sloatsburg Wine Inn. It is also readily apparent, given the significant amount of information supporting this, that at the very least she was an employee of this store, even for a brief period of time, giving her the benefit of the doubt between 2017 and today. There's no mention of this or any other previous ownership or employment at this premise stated in the application. Finally, I also question the veracity of the amount of $25,000 representing the total cost of opening the store as proffered in the application. The submitted application indicates construction would account for $5,000 of these money. I believe after licensing fees, legal fees, rent, assuming it's being paid, and a security deposit, there would be little, if any, funds left to purchase inventory. But regardless of the potential issues I suggested pertaining with regard to the applicant principal, as well as the apparent lack of transparency reflected in the application, this proposed location should not be considered as a replacement store, but rather as a new additional store to the area. When you take that into account and everything above, it's clear that there would be no public convenience, advantage, or benefit to be served by the approval of this premise in such close proximity to an existing store. I would therefore ask that this board act accordingly and vote to deny this application. Thank you.
Go ahead.
All right. First and foremost, regarding the Sloatsburg location, Arena has no ownership interest in that store whatsoever. The owner is Olga Lukashek. She's the sole proprietor of that store. She's the person on the license. Olga and Irina were friends. They worked together at ZSA, and they were roommates. But Irina has no ownership interest. She's never been employed by them. She's never been paid by them. There's no interest there whatsoever.
Well, ironically, you didn't mention she never identified herself as an owner because she has.
It's just took out of context what I was saying. Like that's, Olga was such a close friend. Like she's godmother of my kids. She was in the delivery room with my kid, and I always, with being so close to each other, and even opposition, they already know this. It's just, making me look bad because of maybe my English, or maybe I was worried about something. I said something, but I was so involved in community, and people know us where we used to work, like, because we're blonde and we have an accent. It just came out of nowhere. It's so not true, and opposition definitely knows that, and you should be.
But ma'am, it came out of nowhere 3 times. It didn't come out of nowhere once. You were in 3 separate instances. You identified yourself as the owner.
She did not identify herself as the owner. Even in the Facebook post, they're talking about a charity event.
It's just, and my kids also, I support that food pantry for so long. My kids is, in Girl Scout and a Boy Scout. We support that. So I said support our dream for charity event. It's also and for my friend, it's also maybe my English I wasn't saying the right thing at the moment, but it's, when you're trying to do something good and all this accusation now coming because of me not saying something right, it's actually really hurtful for whatever's happening when I was working so long at that store. And even opposition knows that I have the best character. It just, whatever happening here is so untrue. It's even hurtful.
Have you ever worked there?
At ZSA, yes.
At Sloatsburg.
Sloatsburg, not a day. And it's I do come. She's my best. She's godmother of my kids. And
You're answering questions from reporters. You never worked there, and they're interviewing you.
No. Just maybe when I emotional, she's like my everything. So I said it's because I'm so happy for her. That was her dream, and it's definitely my dream now. Open that store.
Who owned the store you worked at?
It's also from 2004. I did work at it's part of gas station. It's Zulfikar Ahmad, and I used to work for him since I came to United States.
What's his name?
Zulfikar Ahmad.
Where's he now?
He after that, and because the store closed because we had its roof fall down, and that's why the store closed. First of all, I didn't even know. Like I almost got killed in that store, and I believe so. We sent the pictures of that. The store just got closed.
Where is he now?
I'm not even sure. We don't talk. He just told me, the insurance not gonna cover, do anything, just close the store. And I never spoke with him once after that. And I had, I went to regional owner of the property trying to lease the store and reduce. They said, we cannot lease the space for you and you cannot do anything.
Were you in a relationship with him? Personal relationship?
No, I'm married with 2 kids happily.
Why did he call it Irina?
Because he's a Muslim, and when I started working in ZSA, he and his wife, they couldn't even couldn't be attached to alcohol. So when I worked at a gas station, I used to do 12-hour shifts. And they used to be well known in community. So it's better for them to put on me that name so they don't have nothing attached with alcohol because they religious.
How did he pay you? Were you paid by the hour or did he give you a percentage or what?
I had salary by hour, and I had my gas was paid also because it's part of gas station. So when I commute, my gas also was paid there.
Point is, she had no ownership interest in CSA.
I didn't have ownership. I had a dream one day, definitely took over. I just never had a chance for that, and it's just true. And I want to say that the position who is standing there, they know my character, and it's really hurtful whatever saying to me because that's definitely also my dream, and it's my kids. I stopped working in one day, and you guys have proof of that pictures. That that roof fall down. It's not because I know anything else.
Do you have any questions?
No.
Okay. All right. Thank you. Tom, I think we're ready.
Did you vote? Okay. Commissioner Fan.
There is, as we know, one of the 5 Pussy store is closed. All the other stores are showing between 5 to 10% growth. I believe the applicant when she says that she perhaps, use the word we very loosely. I do that too. I get close to my friends and then I think that what they're doing is what I'm doing. But unless I see something where she's actually getting a bank check or something, I cannot, based on what I have, conclude that she had an ownership interest in her friend's store. And so with that, I am going to vote to approve.
Commissioner Ford. If I understand correctly, the store that closed was a little bit, you're Cresthill?
Yes, sir.
So the store was a little bit south of you, correct? The store that
Right
closed?
across the street, like me and...
300 feet, right across the
Street.
street? Okay.
Street.
And the new store is further up the road, north?
Yes, one block.
Even though I see the store's numbers going up, I still don't think that replacing the store that was where it was is the answer to this. I think there might be a need, but I'm not sure that's the location. So I'm going to vote to deny.
Chairman Bradley.
I'm going to vote to deny as well on character and fitness and on public convenience and advantage. I don't think there is any public convenience and advantage to adding another one. I don't believe a word she just told me. She didn't mention that she was the owner once. She mentioned it on 3 separate occasions. 2 of which were to reporters who actually went to her and must have believed she was the owner because they were asking her questions regarding the opening of the store. And it's obvious to me that she also must have had an interest in Irina Liquor Store, because otherwise why would the owner of that store name it after her? To me, there's clearly something going on here, and I have a question whether we're being told the truth, so I'm denying it on both of those grounds.
All right, so it's denied 2-1.
Thank you very much.
Next item, 1909, Lavo Cafe, Inc.
Thomas Burke for the licensee, offer of a CNC and a $20,000 civil penalty.
What number was that again? I'm sorry.
1909.
Your clients are there, sir?
No, my client is out of the country. I'm afraid I'm the only one here representing him.
What happened to Miss Weiss?
Miss Weiss had surgery and she's recovering.
Oh, I didn't know that.
She was on the last one.
Yeah. I mean, this guy is supposed to be a restaurant, and he turned clearly into a nightclub. He lied about everything.
Well,
He broke pretty much every law that we have, and lied to the SLA on the application. He has DJs, he had managers, he had security guards, he was dancing, he was buying from liquor stores, refilling. He was lying about the use of the hookah. I mean, I don't.
He was chairman doing all those things, but he has.
Well, I mean, 20,000 isn't even close to cover what I just mentioned. So I don't know why we would keep him open. He had fireworks.
Fireworks with sparklers on birthday cakes.
No, they're illegal. Purchased beverages from Total Wine. 2 managers, not 1, when he wasn't supposed to have any.
They were relatives. They claimed to be owners. They're gone.
And then he's not here today, which I can't even hear from him that he's going to become a restaurant. So what's the hours in this place? What are his hours?
I don't know it. I didn't do the original application, so I don't know his hours.
Where are you at?
His hours will be whatever you want them to be.
I know that.
I'm happy to cancel.
I mean, he has no adverse history. He did a lot of bad things.
He's only been open a year. He's got quite a bit of adverse history.
Not only that, he wasn't even open. It was 6 months. He was open in May of 2018. All this happened in January.
Yes.
He's got adverse history now.
He's cleaned up his act. Could you give him another chance?
I don't know that we can. The fact that he just pointed out that he lied to us that recently is, go ahead.
I'm going to cancel on bond.
Counter offer? Okay, can you move forward?
I was at 50,000, so it's a counter offer.
He came in and he obviously, I did this license, I'm assuming, and he lied right to her face about what he was going to do, so I'm going to cancel too.
Cancel it is.
Are you okay with that, Commissioner Ford?
Yes.
All right. Cancel on bond claim with counter offer. All right. This counter offer been made, you'll get a letter. Ms. Weiss will get a letter.
Thank you very much.
Next item, 1917, La Botella Bar and Restaurant, Inc.
Thomas Burke again for the licensee. The licensee is Jose Cisneros. This is his nephew, Santos Arias. His grandson, His grandson is here because his English is not perfect, and his grandson is here to translate if and when it's needed. This is a request for a change in method of operation. The licensee is asking that on the weekends, Friday and Saturday, you extend his hours to from 1 a.m. to 4 a.m., and he's also asking to have a DJ and dancing on the weekends.
It sounds to me like he's trying to morph the place exactly into what it was in previous method of operation, which we canceled.
And when he applied, he only asked for 3. Now, and we wouldn't give him that. Now he thinks he's done enough to get 4.
Well, he he's built a good customer base, and he's in a really desolate area in Newburgh, and there's really no place for people to go. And the people who enjoy his restaurant have asked him it would be nice to have a place to dance and hear music on a Friday and Saturday night. So he's a good businessman. He sees there's money to be made, and he wants to accommodate his regulars, and so that's why he's asking for this.
Have you seen their Facebook posts, etc., where they identify themselves as a dance and nightclub already?
I'm afraid I haven't seen that.
So, if you're coming in here trying to pretend like they're about to change, I think you're mistaken. I think they are already a nightclub. And I went back and watched the video, and Commissioner Ford and the chairman definitely issued the license and explained it to the applicant that there was to be no live music, no DJs, and no dancing, and that was not going to change. And that was the basis of them granting the license. And at the time, the licensee was amenable to that.
And I assume you voted against the license?
I wasn't here. And so, no dancing means no dancing. The chairman said that. So I'm going to vote to deny because I don't think that...
And I'm going to vote to deny too, but the scarier proposition is you better clear that Facebook page because you can guarantee that somebody's going to be showing up there in the next few days.
Okay.
Denied.
Thank you very much.
And make sure there's no DJ, no live music, because if it is there after this, there's going to be a problem.
Okay, I will take care of it.
Do you want to repeat the announcement?
Oh, yes. Before everybody leaves, you don't have to leave. We have a new council who is sitting to my left, Gary Meyerhoff, who came aboard actually yesterday. And he will be seated in New York City, but he also will be spending time in Albany. He comes from an international law firm of 25 years, last 15 or so as a litigation partner. And I want to thank Mark Ferring for being the acting counsel for the past 6 or 7 months. He did a great job, but it's good to have Gary on board. He can anybody that needs to speak with him can certainly reach out to him and welcome aboard. So thank you. You want to talk about the other?
Yeah, also 2 reminders. Next Monday, the 7th, is a special meeting of the members regarding the proposed advisory on third-party providers. If you haven't submitted something, it's too late. The members will be present in New York City for this meeting, although it will be video conference to Albany and Buffalo. And the second thing is for the attorneys and non-attorneys who represent applicants and licensees. The chairman is having a meeting, an informational meeting, on the 22nd. And just to make sure there's no confusion, this is just for the attorneys and the non-attorney representatives. It's not for licensees. It's not for trade associations. There is a link on our website to RSVP to the event. And that will also be held in New York City and video conference to Albany and Buffalo.
And when he says it's not for those particular interests, it's because the meeting is geared towards the application process and preparing the application. So there would really be no use association or to a licensee itself unless you do this for a living. What we're going to do is go over some of the common issues that we see in the applications. In fact, we're bringing a couple people from licensing down to explain that to the representatives and the lawyers. So that's going to be the majority of the meeting, and we're not going to be discussing other issues.
All right, moving on to calendar. Next item, 1919. Why is Us Corp?
Good morning, Robert Swetnick for the applicant. I believe there's opposition.
Is the applicant here, Mr. Sputnik?
He is.
Good morning, Charles Lynn for the opposition. We are protesting based upon public convenience and advantage. I am the attorney for 4 of the closest stores to the above referenced new applicant. This area is well serviced by the existing 10 stores in this area. The area is being well serviced by 6 stores that are within only 2.2 or 0.3 miles of the applicant. The stores that I represent are Dan Supreme Supermarket at 1175 3rd Avenue, Premier Wine at 1408 2nd Avenue, Manhattan Wine and Spirits at 929 Lexington Avenue, and B&M Liquors at 1349 3rd Avenue. There was a recent application just disapproved by the authority, Winehattan and Liquor York INC at 1025 Lexington Avenue between 73rd and 74th Streets under serial number 1313636. It was disapproved by the full board on April 10th, 2019, only about 4 months ago, with reconsideration denied on May 2nd for public convenience and advantage. Next to my application is Exhibit B, is an area survey showing that the Winehattan applicant is just 0.18 miles away from this current applicant, but this applicant is even closer to all of the other stores in the surrounding area, closer to 6 stores, and this applicant is again only 0.2 to 0.3 miles away from this applicant, 4 or 5 minutes walking distance. As far as gross sales figures are concerned, the closest store, Dan Supreme Supermarket, well, there's some differential because there's 6 stores that are very, very close. Dan's and Millennium, either 1-2 or 2-1. Dan Supreme Supermarket evidences significant decrease in yearly sales since 2016. The third closest store, CRU Wine and Spirits, was just licensed on a transfer on 12/5/2008, so we don't have any real figures for them. The fifth closest store, Manhattan Wine and Spirits, on Lexington Avenue, shows moderate decreasing sales, and again, the authority requested 5 stores rather than the 4 because of the closeness of all. The other stores, Melissima on 2nd Avenue, 1355 2nd Avenue, evidences increasing sales, although 50% of the sales of Melissima on 2nd Avenue is made up of internet sales, and Premier Wines at 1408 2nd Avenue does have increasing sales. So what we have is we have 2 stores that show increasing sales, one store that shows decreasing sales, another store that pretty much stagnant, but it is side of decreasing sales, and the 5th store not having only been licensed for less than a year. Also, I included McCabe Wines and Liquors on 3rd Avenue. The reason being is that they did not appear on the website when Winehattan and Liquor York listed the closest stores. They were second closest. Here, the distance that I have on my survey, which I next as part of Exhibit A, shows that it is 0.3 of a mile away. So it's like incorporated amongst the 5, 6, and 7 closest stores. So it is important and relevant because it also is on 7th Avenue, and I have the manager here, and I understand that they are showing decreases.
That's 3rd Avenue or 7th Avenue?
3rd Avenue. I'm sorry, I said 3rd Avenue. I'm sorry. One of the things that are also very important is demographics. I mean, population is pretty difficult in the city to be able to get on the internet, but with demographics, it should be pointed out that about 3 years ago, the 2nd Avenue subway was finally completed, and that changed the whole demographics of this area. It made a change in the sales and the public traffic in the area. And what's interesting is that kind of can be reflected in the sales figures, because when we look at remember I had said that there are 2 stores that have increasing sales, 2 stores that have decreasing sales. The increasing sales, Dan Supreme and Big Apple, have increased in sales. They're on 2nd Avenue. I'm sorry, not Dan Supreme, Millisuma. I apologize. Millisuma and Premier Wines, which is doing business at Big Apple. They're on 2nd Avenue. They're the two that have increase in sales. The stores that are on 3rd Avenue, Dan Supreme has significant decrease in sales, and B&M, doing business with McCabe's, also has decrease in sales. And Manhattan Wines has, who is on Lexington Avenue, has decrease in sales. So there has been, when you look at the area and are familiar with the area, there has been a significant demographic change because of the finishing of the 2nd Avenue subway, and that's sort of reflected in not only these retail sales of the stores, but if you walk the stores along 3rd Avenue, there are a lot of stores that are padlock closed, and they're in no way similar to the type of business that's happening on 2nd and 1st Avenue. So,
but you're only you're a block away from Millissima, the new store.
Block
away. It's on 2nd. This is on. I'm sorry. It's on 2nd.
No, Millissima is on 2nd Avenue, a block away.
I'm sorry.
Millissima is on 2nd Avenue, and it's a block away.
That's what you said.
Yeah, I apologize. The other one that's also 1 block away, very, very close, which is on 3rd Avenue, is Dan Supreme. And it's interesting because Dan Supreme has significant decrease in sales. Millissima has had increase in sales. So I'm saying that it's very difficult to have a dispositive decision with regards to sales because of the significant difference where you have 2 stores that are increasing sales, 2 stores that decrease in sales. One hasn't reported, and another one on 3rd Avenue has had decreasing sales, and another one on Lexington Avenue has had decreasing sales.
Okay.
So based upon proximity, where you do have 6 stores within 0.2, 0.3 miles, where you do have sales figures that are really not dispositive of what really is being reflected in this area, although you do have a change in demographics. And in addition, you do have 10 stores within 0.4 miles. I have that on my area survey, which I put on Exhibit A. One would think that there isn't any new products or new services that the new applicant would able to bring to this area with 10 stores within 0.4 miles. So I would ask that public convenience and advantage not be served by this new applicant based upon proximity, gross sales, the demographics, and also, as I said, I do not believe that there could be, considering all the stores here, anything new which this applicant brings to the area.
Thank you.
Good morning. First, as the Commission shows, that what the applicant wants to do is specialize in wines from Israel and kosher wines. He also has 3 major importers who have given letters of support indicating that they are looking for stores such as this to promote their product, that they believe this is a perfect area for it. As Mr. Lynn indicated, the 2nd Avenue subway recently opened, and that is bringing many, many more people into the area, and it's also increasing the sales at those stores on 2nd Avenue, which were virtually blocked for many, many years. Also a Target store going in 1 block from my client's store on 3rd Avenue, which should be open in about 6 months. The other stores in this area are more 900 feet away or more. Others are, there's one 900 feet, the others are a little over 1,000 walking distance. In New York, as you know, carrying liquor for 4 blocks is not something people choose to do. So I believe that the community will be benefited by having a store which they can easily walk to, having a store which is specializing in Israeli and kosher wines, and having a store which wants to do educational seminars to promote these type of products.
Are none of the other stores carrying Israeli or kosher wines?
They have a very limited supply. He's going to basically specialize in that. So I'm not saying you can't get a wine from Israel or a kosher wine, but you're not going to get the extent.
But can you go? But so you can go to one of the 10 liquor stores within 0.4 miles and find a variety of different ones, I would assume.
I don't think anyone in New York goes to a store half a mile away, 10 blocks away, basically walking to find a bottle of what they want, with all due respect.
Well, I lived there for 11 years, and I would
And you would walk 10 blocks?
disagree with you. But go ahead.
No, that is basically it. Is I think that because of the product line, there are new buildings going up in its immediate vicinity, as we've told you in the submission, which is going to add much more density. You have the Second Avenue being completed.
Let me ask you something. What was the reason he didn't put down that he owned, that he had? I realize he has three former licenses. Yet when he first applied, he didn't put 2 of those down. Why?
I would say it's a language matter to me because I wasn't even aware of it. He filled it in, and he filled in his one app license.
And then he's owned 2 liquor stores previously that he then sold. Is he in the business of selling liquor stores?
No, well, what happened is that his wife became critically ill with cancer, and basically he took time off to assist her and to help with her store, and now she's better and he wants to get back into the business.
Does she own it? Where's her store?
86th Street.
Oh, so he was the manager at her store.
He was supervising it. I don't even know if I'll say he was a manager. But while she was not able to go there on a full-time basis, he was going there. They did have a manager.
Is that the only store she's ever owned, or has she had multiple stores?
Another store, your wife? No, no other stores.
And how long has she owned that?
No, since about 19 years.
So 2000, approximately. Okay.
Mr. Chairman, could I just address the Jewish wines and also Second Avenue Subway? So I have Jeff Saunders from McCabe who addressed that he sells substantial amount of kosher wine.
Sure.
Jeff Saunders, McCabe's Wines and Spirits. Last week I had 100 people at a kosher wine tasting. McCabe's is known as the largest kosher wine store on the east side. I totally disagree with this gentleman. When you have this selection, as I do, they do come from every place because they talk. We do business with all the synagogues on the east side. I probably have 300 or more kosher wines, with kosher wines priced at $100 and above. We have some of the best selections ever. Thursday last week when we had 100 people, it was all doctors and lawyers, all buying high-end products. We are and always have been the biggest selection of kosher wines anywhere on the east side. So I totally disagree with that. And absolutely, they will walk if they know you have it. Thank you.
All right, thank you.
And he is also on 3rd Avenue. I also have Parita from Manhattan Wines, just to say that Manhattan Wines also has an extensive supply of kosher wines.
Well, you just said it, so we don't really need to hear from her. I believe that.
Believe me, it's like 95 different varieties. In addition to
Yes. We're going to take a minute.
But I would also note that McCabe's is not one of the stores.
Hold on. Remember to get a brief conference with council. All right, after a brief recess to conference with council, we're back on the record on item 1919, Wine is Us Corp. You want to move forward with the...
Yeah, we can go. Go ahead.
Okay.
It's not.
Do you have any questions? Anybody have any questions?
Any more questions?
Mr. Chairman?
Yes.
I did say that I do have Bob Grubman here to just talk about the Second Avenue subway because the demographics happen to be extremely important. And he'll only be 2 minutes.
Okay, go ahead.
Hi, how are you? Brian Grobman from Dance Supreme. So what Charles had mentioned about the subway, the 6th Avenue train has a stop on Lexington Avenue. Our store is on 3rd Avenue. So we're dependent on customers who get off that train and walk east to their residences. But since a few years ago when they have a chance to take the 2nd Avenue line, they don't walk past our store anymore, and that's changed our sales drastically. We presented sales figures that show the sales going down about 25% in the past few years, and I also pulled up a customer count, and it's the same number. So before the train opened, we averaged a weekly customer count of about 1,300, and that's down to about 1,000 since the subway opened up, and we would attribute a lot of that to customers not walking past our store, and I'm sure if there was data available from the MTA on the 456 train, it would show a decrease in customers who use that train after they had the opportunity to take the NQR line uptown.
And you're down 500,000 over 4 years?
Yes, that's correct. So we're down significantly, like I said, about 25%, and you're getting to a point where it's difficult to operate a store where your sales are so low. You know, your payroll is still relatively the same. A lot of the other things you still do on a day-to-day basis are still the same, but your sales are down so much that it's very difficult to operate a business for us right now.
Okay, thank you.
We ready to vote then?
I just note, as Mr. Lynn
Hold on. You want to hear from Mr. Sweatmaker?
What do you want to say?
I was only indicating that since the 2nd Avenue subway opened, other stores are having an increase in sales also.
Not on Third Avenue.
I believe some of them on 3rd Avenue also are having an increase in sales. I don't know what.
That's not what I see, but perhaps they are increasing on 2nd Avenue because those sales would move to 2nd Avenue. But go ahead. Thank you.
Okay.
All right. Ready to vote then? Commissioner Fan?
The applicant clearly has the right experience to have a kosher-focused wines liquor store. And I feel like my job is to really judge solely on public convenience. It's, you know, I can't control the flow of the people and what happens when trains open, etc. But I do know that 72nd Street has two-way traffic, and that's where the crosstown bus runs. And so I can visualize that there are people that will get off the bus and go to this big corner on 72nd and 3rd and buy their liquor. And especially, there are a lot of temples and synagogues around that area, and that community is very much, you know, encouraged to walk in nature, and especially during Sabbath and during holidays. And so I'm going to vote to approve because I think there is public convenience to the people that this applicant wants to serve. And the more the better. You know, if they're only walking, you know, 1 block less it adds up.
Commissioner Ford?
I'm going to vote to deny because I think there's enough stores on top of one another there. One store did not supply us with their numbers. Second closest store, which is on 3rd, is actually decreasing. And I do think there's probably a decent amount of Israeli Jewish products in the neighborhood. So I'm going to vote to deny.
Chairman Bradley?
I'm going to vote to deny too. There's 10 stores within 0.4 miles. The way I see this, I realize he wants to specialize in kosher wines, but within those 0.4 miles, and based on the testimony of one of the liquor store owners, it would appear that there is a selection of kosher wines available within a short walking distance. To me, this would be selling the same products to the same customer base. And I just think at this point there's enough liquor stores in this neighborhood. So I vote to deny.
The next item, 1904. This is South Brooklyn Liquors. This is a matter returned to you after litigation.
Francis Buscemi for the applicant.
Can I just make an appearance? Charles Lynn for the protester.
So before you get going, Mr. Lynn, I don't know if you read the decision or not, but there's not a lot. Our decision is either to appeal or not to appeal. There's not, and grant the license. There's not a lot of things we can rule on otherwise. So I don't know what the opposition is here to say.
No, I understand. The opposition is here for the interests of justice that possibly the liquor authority will appeal this matter. I submitted, apparently it wasn't given to the board members, my reasons for requesting an appeal.
We have
that, but I just can't. There's no point in us taking testimony from all these liquor stores. I mean, this is a legal determination. It's not really a determination on public convenience and advantage at this point. It's a decision about whether we're going to further litigate this thing or or grant the license, one or the other.
And they're here only to implore the authority to hopefully appeal this matter. That's why they are here.
Okay. I'm going to take 2 minutes with counsel.
You would do executive session if you want to have a conference with counsel. It is litigation.
All right, we'll go in executive session.
So the members have returned from an executive session to discuss the litigation. No decisions were made during the executive session, and we're now back on the record.
Okay. I mean, I don't think we need to hear from anybody, so in my view.
So I guess the first...
Mr. Chairman.
Mr. Lynn?
They're not voting yet.
Mr. Lynn? First question would be whether or not you go...
What do you want to say? I just said I don't think we need to hear from anybody. There's not, as I said, this is a legal determination we're making.
I fully understand that. I apologize, but I have 15 individuals here who are absolutely obsessed with making a statement, and I have one individual, and I think if it was 1 minute, that it would be in the interest of justice to allow him to...
Then that's 15 minutes.
How many are you representing?
There are 20 individuals here.
Are you representing all of them?
Only the ones that I represented when I put in my protest.
I'm not hearing. We're not listening to 20 people. This is.
No, I'm asking for one. One
All right.
individual.
Go ahead.
Before that individual talks, I haven't had an opportunity. I just want to point out that I did serve a certified copy of the judgment on the Liquor Authority on August 30th.
I got that.
Okay.
Good morning, Commissioner. Good morning, Mr. Chairman. I'm the owner of Wines and Liquor Center. My name is Stephen Lerner. You see, it's about 20 of the stores here with us today. I'd like to say a few words.
What's your name, sir?
My name is Stephen Lerner. On May 1st of this year, SLA gave us all the reason and understanding why we have a liquor license. Realizing all the facts and considering all the evidence, SLA determined that having another store in such saturated area is detrimental to our survival. Rejection of the applicant's license gave us tremendous confidence and understanding that well-being of our licenses are protected by the state. After all that said, Mr. Buscemi and his clients decided to take an alternative route and bring their rejection to the Supreme Court, to the appeals court. Mr. Buscemi decided if there's another loophole, that they should take a shot at it. It's very disturbing to all of us, and we're very puzzled to understand what happened in the courtroom. Only partial evidence were presented. Not all the facts were looked at by the court. Court had to make a decision by having only some evidence, which were definitely not enough to vividly understand the concern of the community and people living in it. There were many things that were not, I read the court decision, there were many things that were not presented there. There was, as we said in our original on May 1st, that there was 15 stores within 1.3 mile radius. There's 4 stores within 0.5 mile radius. And the only facts that were considered, it seems like in a court, were the facts that were beneficial to the plaintiffs. Court states that the chairman and the commissioners made the decision using speculative measure. By stating that another store would not be a problem in the community, the store would not cause any issues. But here, the chairman and the commissioner, you were not speculating. If you do not put a store in such an area, I'm sorry, I'm very nervous. You do not put a store in such saturated area with all existing liquor stores. They will push all these owners to act not with accordance of the law. In a human court, if you ask one would you do everything and anything possible to protect your family, to protect your kids, to protect your loved ones, to protect your investment, to make sure you put food on the table and continue in your business? I think the answer is yes. And you, Chairman and the Commission, you do this every day, listen to thousands of cases, and yet Supreme Court Justice decides that you were speculating. You were not speculating. You were stating a fact because you know from all the experience that by putting a store of that caliber in our community, only being 0.5 miles away from 4 other existing stores that you can walk within 3 minutes, it's going to basically be a cutthroat, very competitive style of business, and a lot of stores will just have to close their doors. Also, I want to add, if one goes to a doctor, just an analogy, and the doctor says that here's the medication because you're sick, and if you don't take that medication, you might acquire certain consequences and maybe even die. Is it to say the Supreme Court can look at that statement by the doctor and say, oh, the doctor is speculating? No, the doctor is not speculating. The doctor is stating the fact from all the experience by using that medication that unless the person will take that medication, he will maybe die or get very sick. And you did exactly that on May 1st. You rejected that license.
No, sir, we understand what the history is here. So if you could finish up, I'd appreciate it.
We really hope that you can vote to appeal this case in an appeals court and give us a chance to intervene, which you didn't have a chance to intervene because we were not part of the Supreme Court. We were not in the courtroom. We couldn't intervene. We didn't have an argument. Mr. Buscemi had a chance to argue with the Supreme Court justice, I assume, but we were not there. We were told to sit and wait, and as it seems right now, we were sitting basically waiting for prison for execution, because at this point, we will not be able to possess all the proper facts. There was letter from community boards. There was letter from Ms. Assemblyman Simbrowitz. There was letter from churches. There was letter from public school institution. All that were presented on May 1st, and they were not. It seems like they were not presented at the court when the decision was made. So we ask you, a committee. We ask commissioners. We ask the chairman. Please give us a chance to go to court, to intervene with the council, and show all the evidence that needed for them to understand why the original decision was to deny is a correct one. That this store is a conglomerate will absolutely have to close doors on so many stores and put a lot of people in the business. I will cause a lot of owners to go into a cutthroat mentality where they have to do stuff not in accordance with the law.
All right, thank you.
I mean, you have to confirm with your lawyer, but my understanding of how the Court of Appeals work, that appeal process, is that they're really only going to review what is already in the evidence. They're not going to really allow new participants to submit evidence or anything like that.
That's correct, Commissioner, and the full record.
Sir, thank you. She's talking to him. Thank you.
I'm sorry.
I think we're ready to vote. Thanks.
I just want to point out that I
Mr. Buscemi, hold on. Mr. Buscemi, you're ready
Yes.
to vote. I think the question would be either that you're going to appeal or that you're going to not pursue the appeal and direct that licensing issue the license.
And to that end,
Mr. Buscemi,
We're
I know,
voting.
but
We don't need any input. Thank you. No
I
more.
haven't received a notice of appeal. It's been 33 days.
Mr. Buscemi, shut up. Commissioner Fan.
The statute of limitations is right.
Mr. Buscemi. Commissioner Fan.
I sympathize with all your concerns about this vote, and I appreciate that you guys all showed up today, and it's overwhelming to see the presence of so many bodies in that room. I don't think I've ever seen that before. But with that, I believe our time to appeal has run, and I think perhaps the store owners have a different understanding of what your role would be if there were an appeal. Our counsel's office, it's have the experience that suggests that we will not win on appeal. And so with that, I vote to issue this license with the 3,000 square foot limitation that was suggested on May 1st.
You're actually voting not to appeal.
Yes, I'm voting not to appeal and issue the license and continuing with the limitation of 3,000 square foot of retail space.
I don't know how you do that, Commissioner Fan.
You offered 3,000 square feet. She voted on the 3,000 square feet. That's what we're sticking with. Go ahead.
That's not what's before.
Well, the judge didn't really make the judge in her infinite wisdom didn't really make it clear what was before us, and we're going based on what your client offered when we did vote, and he offered 3,000 square foot retail. Go ahead.
Well, to be fair, he offered 34.
He offered 34. He offered 34.
All right, well then we're taking 3,000. Go ahead.
I looked at this, and I know I was one of the two that originally denied. I looked at the opinion of the court, and it hasn't changed my opinion. I'm still at a question of denial. That being said, I'm not quite sure it's going to give any other result to send it back and appeal, but sorry guys, but I'm willing to send it send it back to appeal. Clap yet. Don't clap yet.
So I'm going to vote to not appeal. I'm going to vote to grant. We're ordered to grant the license. The only individual who voted for the license on this board was Commissioner Fan, and she voted on it on the basis that the retail space would be 3,000 square feet. So I'm ruling that the vote should be based, that the license should be granted under the basis of 3,000 square foot retail.
Next item is 1956, Pancho Villa Restaurant, Inc.
Good afternoon, Mr. Chairman.
Hold on 1 second. What was the number?
1956.
Okay, go ahead.
All right, good afternoon, Mr. Chairman, Commissioners. I'm Harry Foreman. I'm the licensee, Pancho Villa Restaurant, Inc. Next to me is Monica Franco. She's a principal. And next to her is Pedro Franco, who's going to translate for Miss Franco. Miss Franco does speak some English, but she would be better served having a translator for this proceeding. This was an application to change the method of operation of this restaurant, which only has a beer license. We withdraw.
You actually have a wine beer license, but go ahead.
Okay, I'm sorry, wine beer license. We withdraw the application for a DJ. We're asking.
So
there's several things. There's a application for a DJ. It says pre-recorded music, jukebox, and security guard.
Are they doing this already? Do they already have the DJ?
At one point there was one, but there isn't any longer. So they're withdrawing, and they were cited for that. They paid a penalty for that. We're withdrawing the application for the DJ.
How about, is the kitchen open all hours now yet or no?
Yes, I'm informed, yes. We're seeking no change in pre-recorded music, which I understand has already been granted, I think, in 2017. We're asking the only changes we're seeking now is to add a jukebox and to add permission to have security guards. There's been no opposition by the community board for this application.
There's been no response from them, actually.
So you don't want a DJ, and you don't.
We're not seeking a change.
Nothing was added in 2017.
I wasn't the person involved, but I was informed that there was an application in 2017 asking for pre-recorded music, and that was granted. The person
there's nothing in our file about an application. There's nothing from 2017.
All right. Well, then the person who handled this application, I'm not the one who did it. Mr. Carabello's office told me that they thought that it was granted. If it's not granted, I'm asking.
But they're requesting it in this application.
I see, and I asked them about it because I saw it's requested. And they said they already have it. But if they're wrong, then I'm asking for pre-recorded music and a jukebox, no DJ, and we're asking for a security guard.
So basically, you want to become what was there before.
Well, but they stopped doing it because they didn't have permission. They had security guards before, but it wasn't in their method of operation. So they're seeking to have security guards now. The last time the issue came up, if I remember, I think the board pointed out that they need to get security guards approved on their method of operation. So we're applying for that. We're applying for security guards, pre-recorded music, which I thought they have already, and a jukebox.
Can you really go just back up and explain to me why a Mexican restaurant needs security guards?
They want.
You have a restaurant wine license.
It's not a lot of security. They're asking for only 1 to 2 security people to check IDs of people that are ordering drinks. and just to be there, just because of the location.
Because they become a focal point for police activity.
Well,
$5,500.
that happened once.
No,
No,
you become a focal point because stuff happens over and over again. Doesn't happen once.
They've never been decided for disorderly premises.
Yes, they have.
Yes, they have in 17.
Not that I was aware of, at least not in the last.
But it was a unique disorderly premise because it was two of their waitresses attacking each other.
Well,
You don't hear that one every day.
I'm in the last 2 or 3 years, 2 years, let's say, I don't see any of that. Maybe it happened before then. If not, I'm not aware of it. But I
mean,
think
sir, when
2017, 18.
So when you're representing your client, I mean, I don't know why you are skipping lines or using a shorter time frame. You need to look at their whole history.
I mean, a lot of this stuff is from this year.
Well, I know it's from this year. They
I
have
mean,
a
you-
card issue and a sale of alcohol and the DJ equipment. So now we're withdrawing. There's no DJ now. We're withdrawing the request to have a DJ. We are asking for security guards, and we'll also ask for pre-recorded music, which I was wrongfully advised that they have.
Why don't we see if they can run as we signed them up to run for a year and then come back and ask for this? Because in my mind, given what's been going on here, they've been doing all of this already, even though we didn't allow it to happen. You become a focal point, your waitresses are stabbing each other, you're not a restaurant, you're closing the kitchen, it appears whenever you feel like it. You had a DJ already. So why don't we see if they can be a restaurant for a while and then come back and see us?
But I'm only aware of one date.
It's what I'm aware. What I'm aware of and what we're aware of is what's important, not what you're aware of. You don't seem to be aware of a lot.
Well, no, I'm saying is I'm aware that there was one incident where they were cited for having the restaurant closed at 12:50 a.m.
So how about you, during that year, you go back and find out and become aware of all this stuff I'm aware of, and then we'll talk about it in a year.
I believe I am. I may have been wrong as to one thing, but I believe I am as to all these other things.
There is one thing I'm willing to give you. I'm willing to give you security guards because it sounds like you may need them.
Well,
but nothing on the music.
We're trying to do things properly. We're trying to have the right security, and we withdraw the request for a DJ.
All right, we're ready to vote.
Mr. Foreman, they're going to vote now.
I'm going to go with the chairman. I'm going to vote to deny for now. I'll see you in a year.
And I would vote to only approve security guards.
And I'm going to deny it all. And see it. And if you come back and there's nothing going on in a year, then I probably will grant it.
Are we granted security guards now?
No.
No security guards?
No security guards. No recorded music. You're not approved for that.
All right. Thank you. Thank you.
Thank you. Okie dokie. The next item. 1918 Bayport Mart, Inc.
State your name.
Gurminder Singh.
The applicant.
Mr. Singh, you know two other applications at this location were disapproved in the last 2 years. Are you aware of that?
No, sir. I've been this location for 2018.
How did you come about this to this location?
I leased from a landlord, and that place is closed when I lease it.
I'm sorry, what did you say? Can you say that again?
Please repeat that.
The location is closed when I lease from a landlord.
He was the manager at the place that was here before.
Got it.
And it closed.
And does the place have any...
wait, no, sorry, take that. No, that's not. He was a manager someplace else and it closed.
You have two other licenses right now? Oh, no, it closed. Okay, you don't.
That thing is closed. I used to run.
Jonathan, are you in the room?
Yeah.
Are you understanding him and it's just not coming through, or am I?
He's speaking really low. Let me move one of the mics over to him.
I think, Jonathan,
Yeah. Hmm?
I think you're trying to figure out where he was the manager.
Well, I just want to make sure he understands us, and that because I can't understand a word he's saying. So you do have a license right now, right? In Nassau?
Yes, I have a license in Nassau.
And that has no history. Looks like it has one. Okay, nothing to me. All right.
So tell us again how you came upon this place. I'm sorry. You drove by and saw it?
No, someone recommended me for this location. I see
Someone recommended it to the location.
for sale sign on it. The location was closed. I see for sale sign on it, and my friend told me that.
Oh, okay. Okay.
So you already bought this place?
Yes, I'm running this place now.
And is it already open?
Yes, sir.
All right. I vote to approve.
I vote to approve as well.
So do I.
Good luck.
All right, you're approved. The next item, 1938, 7905 Tavern Court.
1938.
Yes.
1938.
Good afternoon, Brian Solomon for the.
Offer, cancel, and bond.
Yes.
Paid $50,000 so far in fines.
Yes, the license has actually been surrendered. They sold the business about 2 months ago. So they're no longer operating.
All right. Cancel and bond. Accepted.
Thank you.
Second.
The next item.
Hold on. Can you put a location stop on that then? Or do we need? I don't need approval. I mean, we can just do that, right?
Yes?
Yes.
But in practicality, that just means
It would probably come to you anyway
Right.
because of the history, but
Yeah, but if I see it, you know what I did it.
yeah.
So it just has to come back to us.
Yep. All right, the next item, 1886, JMW Restaurant Bar Lounge LLC.
Francis Buscemi for the applicant.
So we had put this over for you to contact the community board.
Yes, exactly. I did contact the community, but in fact, I sent you a series of emails because I initially notified them by telephone. No one had gotten back to me after they had indicated that they would, and then I started emailing. I also sent the community board photographs, which I sent you. It's a theme, airplane, jet plane theme restaurant, tavern. My client did sit down at the community board on Monday. Finally, they said come in on Monday at 1 o'clock. He did sit down with them, and their main complaint was that was concerning the notices, the 30-day notices. We originally noticed this community board back in 2016, actually, when the project was just getting underway. And there were tremendous delays concerning this. And the postmark on that was March 1st of 2016. Because of the delays, it took like 2 years to get gas line in and all this stuff. We didn't file. But what I ask you to be cognizant of is that the community board never contacted us concerning the original notice of March 1, 2016. So then, so much time had gone by, I re-noticed the community board on November 28th of 2017. And the community board said, oh, I never saw that 30-day notice. So I gave them a copy of it just the other day in an email that I sent them. I gave them a copy of it. I checked my delivery on it through the post office. was delivered on 12/4/2017 at 4:49 p.m. to the community board office. So we never received any contact from them on the 2016 notice. We never received contact from them on the 2017 notice until I started emailing them. Then they finally gave my client a sit down at their offices. And their complaint, I wasn't there, but my client was there, Mr. Reynoso, Wilson Reynoso, and it's my understanding the complaint was that they didn't see this notice from 11/28/2017, which was delivered to their office on December 4th, 2017. You know, and you can check the tracking on that yourselves. We do want to operate this theme-style jet plane restaurant. It's on Webster Avenue, 2755 Webster Avenue, across the street from the railroad station. It's for the most part, it's a commercial strip, large commercial strip. You have the method of operation there. This does have a full kitchen, and it will have a full menu.
Both principals had licenses canceled.
Yes,
one 2016, one 2018.
I think there was a cancellation on Arrow Lounge. That was Mr. Reynoso's license. I thought it was in 2015, but I believe the license was surrendered. My understanding is the license was surrendered. Then there was after the license was surrendered, the liquor authority, it basically was a default situation. A $6,000 or $7,000 civil penalty the liquor authority imposed that the licensee was unaware of. He was no longer in business there. And then, since it wasn't paid, the liquor authority canceled. The more recent 2018 is based on a CNC offer from Mr. Tatis.
So one principal owes us $7,000 plus interest, and the other one just had it canceled.
He did a CNC offer. I wasn't involved in that.
Prohibited hours of consumption, disorderly premises. I mean, I don't, like, now they want a place that's going to hold 518 people?
Yes, but I mean, it's a different type of situation. Again, it's that
it's
highly themed. If you can see some of the pictures, we brought other pictures as well. I mean, the whole area is done as a plane. They've even brought in a cockpit area of the plane. The bar is the plane's wing, with the turbines behind it on the back bar wall. They've used those compartments in the plane for storage areas. I think you can see in some of the photos the airplane seats or the seating areas to have dinner in, things of that nature. I have other photos. I can hold them up. I don't know, in addition to the photos that you were sent, I don't know whether you're able to see if I hold up any photo.
No.
So what happened at the meeting with the community board? I mean, are they writing something?
They would just, the district manager was complaining about not getting the notice, which and my last email to the district manager was that I gave her a copy of the 2017 one, told her that we had given the community board notice in 16 and in 17, and that we never received any response.
So you didn't come away with the support from the community board?
Correct.
All right, I'm going to vote to deny.
I mean, they're on record being against this. That's part of the problem along with your client's history.
Well, again, this was just on Monday that the client had an opportunity to sit down with the community board.
We understand that, but prior to that, they asked us to deny the license based on the 500-foot law.
Right, and I understand that, but again, the meeting was short, basically a discussion about the notice, which I sent a copy of at the last minute to the district manager prior to voting to deny. I would ask that the matter be put over once again perhaps we could sit down and have a more lengthy discussion with the community board.
No, I can't. No, we put this over.
I mean, you know, I think maybe a year, maybe it will take you a lot longer to sort of massage that whole relationship into a positive support for you. And so you know, just come back, just refile in the future.
Okay, you ready?
So
That'd be another 6 months.
That means they're going to vote now.
So you say you just met with the community board, is that what I heard?
Monday afternoon, Commissioner.
And you have nothing from them in writing yet, that they've changed their
No,
opinion?
nothing.
They only met with the district manager. They're not meeting with the board. The district manager won't do anything without the board.
So that's why I'd like an opportunity.
Mr. Buscemi, they're voting. Okay.
Well, I'm being asked questions, Mr.
No,
Dunning.
the question is over. You answered it. Thank you.
Oh, you're waiting on me?
Yes, sir.
I'd be willing to hold this over for another meeting to get something in writing from the community board. If that was agreed upon, how long would that be?
I'm sorry, is that a question?
I'm asking you, Mr. Buscemi, how long would that be?
I would ask to be held over to the one after the next meeting, which would be
I'm
what?
not. I mean, she already voted to deny. I'm going to vote.
Yeah, all right.
So is that your vote? You want to hold it over?
Yes.
Okay. I'm voting to deny. I mean, I don't. At this point, I don't even, unless they came back with stipulations signed. Given these two guys' history and the size of this place, there was no way I was going to grant this anyway. They both have canceled licenses one within the last 4 years, the other within the last 8 years. One actually was fined and didn't pay the fine, so still actually owes the authority $7,000 in my mind, so that doesn't bode well for his future cooperation. And this is a 500-plus restaurant, it appears, bar and lounge they call it, although they're applying as a restaurant. And I don't see how 500 people in this area is not going to affect parking, noise, or any of the other things we need to consider when we're doing a 500-foot law case. So I'm voting to. I don't see any public interest.
Okay, the next item, 1924, RM Wine and Liquors, Inc.
Francis Buscemi for the licensee. This is a CNC offer of $6,000.
$6,000
Accept.
Next item, 1939, Gateway Beer Garden, Inc.
Timothy Allen for the licensee.
So, it's after hearing at the request of counsel's office withdraw charge 3 and 4. Then I actually disagree with the ALJ's decision on charge 1. I would sustain it. I think that it was clear based on even what she wrote that they were not selling food for 3 or 4 months. I don't see how that's not non-bona fide. And she also dismissed charge 5, and I would sustain that. She acknowledges in this one that no food is available, and you can't have it both ways. That food was that they were bona fide, but now food is not available. So I would sustain 1, dismiss 2, sustain 5, sustain 6, sustain 7, sustain 8, and dismiss 9.
I think she found that they didn't have food.
Hold on. Commissioner Fan, Commissioner Ford, are you on board with those?
Yes.
Yes.
All right.
All right, you can say something. Go ahead.
Yeah, I think she found that they didn't have food on that evening because the regular cook is the licensee, Singh, and then there's another cook who was unavailable. So it was really just for one night, the judge is saying.
Well, when the individual was interviewed during the inspection, they said 3 or 4 months.
That was a temporary manager who usually is the cleaner that they put in charge for that night.
Well, it doesn't matter. I mean, it's somebody that's working for him. I'm assuming there's no reason he would lie about it.
But they also said there was no food prep area or no kitchen, and we had pictures from that evening that showed there was a deep fryer, There was just the oven that was removed. So I think you're saying the 3 months based on the oven being removed for 3 months. But
Well,
they didn't
I'm doing it based on the fact that one of their employees told the inspector, and there was absolutely no incentive to lie about it, that there was not food for 3 or 4 months. Why would he lie about that? Go ahead.
All right, and the other charge, on 5, I'd just like to say something that, so based on her saying that it was just that one day that there was no food, that the fact that there was no certificate,
No, that's not what
you're saying she can't have it both ways. She's saying there was no food being served just that one night, so they didn't need the certificate that one night. That's what she's saying on 5.
Yeah, but they're supposed to be serving food, so they did need the certificate. You don't get the certificate daily. You don't go and get it on Friday night, I don't need the certificate, but Saturday I do, and you go over to the office of whatever town they're in and pick up a certificate. They didn't have it.
I think she's saying it's an excusable and a de minimis violation to have no food.
I disagree. I disagree with her. The evidence supported it. Based on their history, it's obvious that they're not running the cleanest ship. But so go ahead. We're ready to vote.
I'm at 9,000.
Commissioner Ford? I'll go at 9,000 as well.
I'm at 9 as well, and this will be it.
Okay.
We got a long list.
All right, the next item, 1957, A&M Lounge Rest Inn.
This is also after hearing the licensee is with me and his son to translate.
So this was after hearing withdraw charge 3 at council's request, sustain 1, 2, and 4.
So I did put a letter in on.
Yeah, we got it. So this is a security guard company that they hired, and one of the guards that the security guard company sent over beat and slashed some of their customers.
That's essentially it. He had been there for 2 years and they hadn't had any issue with him. My client was present, said it took about 1.5 to 2 minutes. They called 911. They put him in the bathroom as the fight happened. And when he came out of the bathroom, the police initially arrested the people he was fighting with, and then my client allowed them to look at the video immediately, and they realized he was the aggressor, and they arrested him, and he cooperated fully with the police.
Did he just have a nervous breakdown or something? Or
Yeah, he said that he had just separated from his wife. We're saying he snapped. It was nothing that he had ever done before.
All right.
Anything similar.
I'm at 10,000.
Yeah, unlicensed scars. Yeah, and it's third time disorder premises. I'll go with 10,000 as well.
10,000.
Thank you.
Mr. Howard, you signed in on 1913, but the members already voted on that. It was a default.
Okay. What was the outcome of that?
2,000. 1913.
$2,000.
Okay, thank you.
Next item, 1958, Ludo Inc.
Good morning, Peter Smith for Ludo Inc.
Did you guys get a letter from the community board?
So we did. They didn't have a chance to get it completely signed into you, but we have a stipulation in place. We did hold a meeting at the premises about a month ago to meet with the community members who were in opposition. We found on that date that a lot of that opposition towards the noise on the streets, the cigarette butts, the drinks, etc., a lot of that was actually associated with 2 of these quote-unquote dance halls that are on the block and in the neighborhood.
My clients do realize that there have been some growing pains throughout this process. Made restitution, done everything they could do. They paid the $6,000 violation. As I was saying, we do have a stipulation with the community board that will shut down.
Oh, go ahead. I'm sorry. Go ahead.
The stipulation would shut down the backyard at 9 o'clock on weeknights and 10 o'clock on weekends with no backyard use on Sunday, allowing for the direct neighbors to enjoy their backyard use.
And what is defined as weekend for the later closing?
So that would be Friday night and Saturday night.
And it's what time?
9 o'clock?
So it's 9 o'clock during the week. Monday to Thursday is 9 o'clock and 10 p.m. Friday, Saturday, and no usage on Sundays at all.
Yes, ma'am, I apologize.
Okay.
What about music?
There'll be no music in the backyard. That's part of the stipulation as well.
Okay. Are they going to send us something?
I believe Gary Giordano was going to send you something. He sent my co-counsel an email, I believe, either this morning or yesterday, saying he just hadn't had a chance to send it in yet.
All right, I guess we have an email. Okay.
You are really up against other backyards?
We are up against 2 backyards. We have signatures from our upstairs neighbors and a number of those people that are on those 2 sides.
Do you have a smoking area right now?
As of now, we don't. People smoke in the front of the restaurant bar. They said that they're going to hang signs in the bar and outside the bar. There already is a sign outside the bar encouraging patrons to respect the neighbors. They're going to hang another one inside, and they're going to do everything in their power to encourage their patrons to be respectful of their neighbors, not cause noise, not leave cigarette butts out. They put a container for cigarette butts out front, but they really are doing everything in their power to try to be good community members here.
All right. Well, I'm not going to put it as part of the stipulations, but if you can talk to your client, just put the smoking area closer to your own building and not closer to the other buildings. Does that make sense?
Yes, ma'am.
Okay. With that, I will vote to approve with the community board stipulations.
I'll approve with the community board stipulations as well.
I will too, which are those hours and no music outside and no use on Sunday.
Yes.
So just for the record, 9 during the week, 10 on weekends, which is Friday and Saturday.
Yes, thank you very much.
Yeah.
Next item is 1900 Ramona C. Sierra.
Good afternoon. For the licensee, Marconi and Associates by Louis Cesari.
So withdraw charge 8 at the request of counsel's office.
And cancel for the record.
The license is already revoked.
Yes, Your Honor. We had brought in Article 78 to have a hearing held, and the judge ruled with counsel that it should go back for a hearing. Then at the hearing, instead of doing the hearing, we offered cancellation instead of revocation. The people have legitimized the location, for lack of a better term. They've gotten all the necessary COs and permits to turn it from a garage into an actual eating establishment, which I find comical. I'm sure you guys, if you could look at it and say it is actually kind of funny that they turned a garage into a coffee shop. But they have actually legitimized it into a coffee shop, and now they would like to seek a new license. But with the revocation, that becomes a problem. So that's why they wanted to. That's why we offered cancellation instead.
It's the same owners?
I believe the licensee will be the same. They've legitimized everything.
Yeah, no, I mean, you can go do the hearing. I'm back at revoke. I mean, we sent it back for a hearing because I thought it should be revoked.
Okay, that again at the hearing that wasn't relayed to us when we spoke to Stefan about
I mean,
it.
I don't know that I related to anybody, but that was what was going on in my mind, and that's why we didn't. When we sent it back, we didn't offer cancellation when we sent it back. That's my thought, at least. I don't know what theirs is. But the fact that now you're telling me he's going to reapply again, I don't think he should be able to, and if I revoke it, he won't.
Commissioner Fan?
I think I meant revoke as well.
Same here.
All right, so we're just rejecting the counter offer and sending it back to him.
Yes. Okay, thank you.
I have someone who signed in for 1921, 19 Stanton Restaurant.
Yes.
All right, that was a default that members have already ruled on it earlier today.
Oh, really? Is there any way that we can revisit it?
$2,000 penalty.
Okay, great. Thank you so much.
Next item, 1960 and 61.
Anyone else in New York?
No. Okay, Terry Flynn is in a traffic jam. There was an accident on one of the bridges. He said he would not be here until 2 o'clock.
Well, we won't be here by then, so email him back and tell him we're adjourning everything.
We're going to adjourn his cases? Okay, so that would be 1960 and 61.
Well, I mean, leave it for a minute, but I guess what's the point of making him come all the way up? Yeah, just tell him to adjourn all of them. Go ahead.
Well, he's on his way here anyway. He's past the point of no return, so he's closer to here than he is.
All right, then we'll see what happens.
We'll just hold it.
Yes.
Okay. All right, so I have nothing else signed in. Jonathan, anything else down there?
No.
Keep us hooked up in case Terry shows up.
Okay.
And we'll go to 1887.
3,000 accept.
Accept.
3,000 accept.
1888.
6,000 accept.
Accept. 6,000 accept.
1889.
2,500 accept.
Accept.
1890.
6,000 accept.
1891.
Well, hold on.
Did you accept?
I was saying 1889 I accept.
Oh, sorry.
We're one little delay here. 1890?
Yes.
6,000 accept.
Okay.
Accept.
1891.
2,500 accept.
2,500 accept all safety
Accept.
violations.
1892 and 1893.
What about 1894? Oh, you're still
That's the next
See, now
one.
I'm going ahead. I'm trying to
You're
catch
just
up.
trying to get me confused.
I'm trying to screw you up here.
This is a straight no contest, so Commissioner
Yes,
Dan?
I'm at 10,000.
10,000.
10,000.
1894.
Yay!
I vote to deny because
Not a great history, no community board opinion.
Yeah, so they want to increase, they want to add live music DJ and increase security guard numbers. They want to go from 1 guard to 10 because the capacity went up. Also adding a larger room, 88 feet by 44 feet.
You had sent them back to meet with the community.
And they did not meet with the community board to our knowledge. So I'm at deny as well.
Deny.
Until the community board signs it.
1895.
I'm at letter of warning.
I was just like, is this been fixed? No one here to tell us that.
I'm assuming they got rid of the flies.
Yeah,
They were live fruit flies. I'll give them a letter warning.
Letter warning.
That's probably in your 12-year-old scotch.
I'd be count 56.
Oh, you got to meet Charlie.
18. Take off your shoes and.
1896.
Stay of cancel and bond and accept $500 penalty.
Yes.
Cancel bond, $500 penalty.
1897.
6,000 accept.
So
6,000 accept.
1898.
So this is a recon on a liquor store that we all denied. I think, was this
She didn't
unanimous?
come back.
Yeah, so
I will vote to deny.
deny reconsideration.
Yeah, I don't see anything new here based on what we already decided on tonight.
1899.
Dismiss.
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 1901.
7,000 accept.
7,000 accept.
1902.
So withdraw charge 2 accounts as request, dismiss 1, 3, and 4.
And dismiss.
So, I have a question on how this this even came to us.
Well, that I asked that. I'll find out.
All right.
You okay with that?
Yes.
All right. 1903.
I am surprised that we were able to prove the security guard charge last time, and we did not prove it this time.
And the guard was licensed, right?
Yeah, the guard showed the detective an expired identification card.
But it was
that the card during the relevant time period.
We may not have gotten the hearing on that one, on the one you're talking about. So dismiss 1 and 2.
1903 dismissed then.
Okay. 1905.
1,000.
Accept.
1,000 accept.
1906.
Is that the plan?
This is Sullivan and O'Sullivan. You can't make this up.
Since 1981.
I would accept.
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 1907.
2,000.
Blaming it on the lawyers again. I'll accept.
2,000.
1908.
6,500 accept.
That's the 4th sale in 11 years. I guess it's up there. I'll accept.
500.
1914.
5,000.
Yeah, I was going to counter for 10,000, given the history that we're building here in a year.
Okay. 10,000.
Counter 10.
They're going to be closed quick.
That's right.
1920.
Any vote to deny?
Yeah, this is a 500-foot case. They have to prove that it's in the public interest, and nobody showed, so they can't prove that. But I'll vote to deny as well.
1925.
I will accept 11,000.
1925.
No, 23. You missed one. Right, you're on 23. Yeah. No, he's on the wrong number.
Oh, yeah, I am.
Are 2 and 3 redundant charges?
No, one's live band, the other's DJ.
I checked. They're good right now. They're doing pretty good.
So she accepted.
No. 23 is one of terrorists.
Oh, okay.
Yeah. So 25.
So fold that one over. Letter of warning?
Yes.
Wait, what? Letter of warning?
Yeah, that's 1995, so.
Sounds good.
1926.
Accept.
Accept.
Oh, what was 20? What was this one?
So 25 was.
What was 24?
24 we did a. Somebody appeared on.
Oh, I couldn't find it. Okay, because it was out of order, that's why.
26.
Accept.
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 28. 1928.
4,000 accept.
7,500.
Oh, it's fine. 7,500 accept.
7th, I'll accept.
We go with that, Commissioner?
Yes. Sorry.
1929.
4,000 accept.
Accept.
4,000 accept.
1930.
2,000 accept.
I'll accept, but this is
disgusting.
Yeah.
Absolutely disgusting, please.
I mean, if this comes back again like this, he's running. Is it?
Can you note that in this?
We can put down 2,000 in disgusting.
2,000 disgusting. Yeah. So
1931 and 32.
We're kidding. Don't put disgusting. Just
I know.
put, you're a menace to the health code. 31 and 32, withdraw charge 2 in the first proceeding at council's request.
4,000.
4,000.
1933.
Offering cancel bond. Accept.
Accept.
I didn't mean disgusting. I meant next time. That's it. You put that in. That's what I meant.
As part of the license.
As part of it.
We'll put a warning in the notice of disposition saying, it's $2,000, whatever it was, and you're reminded that,
These
future
violations.
violation, you're risking cancellation. We have some generic.
That's what I said.
You know what's sad is they're going to see that and they're going to think it's like boilerplate language.
Yes.
That it wasn't.
All right, so
written
put disgusting.
I'll put down your place of disgusting. This is all right.
Quote unquote Commissioner Ford.
There you go. I made my mark.
1934 and 41.
The Utica Flash.
I have a big question mark on this one.
Okay.
I mean, I'll take it, but this is.
No, you can go up. I would have hit up. Counter.
Counter at 12.
12.
Commissioner Ford, you good with that?
12,000.
Okay. 1935.
6,000.
Accept.
Accept.
1936.
Cancel and bond.
Is the bond available? Oh, that's not due to.
No, the bond we took on the other one,
We didn't get yet.
so it's not going to be available. So it's just be cancellation.
Okay, cancellation.
All right, cancel.
1937.
So they have no liquor. Guy's not selling it. He decided not to sell it.
Yeah, so he doesn't need a license.
So why is he have a license?
Exactly.
You won't once you get done with this.
I said cancel and bond.
Yeah, gotta cancel it. Not even.
Yeah. That pops up.
Yeah.
Paying $3,500 or whatever it is.
1940. And also
Yes, I'm at.
1966. The
I'm
same.
at 3,500 for 1940, and I am going down to 500 for 1966.
All right, so for 1940, Commissioner Ford, Chairman Bradley.
Yeah, I'm good with it.
What was that?
3,500.
3,500?
And then 500 on 66?
Yes. Because
Look at that.
the disorderly was withdrawn, so.
All right. 1942.
You said 500?
Right.
Yeah.
Okay, all right.
Yeah, no, I was good with that. 42. Did you
No, yeah, 5,000 or so.
accept?
5,000 accept?
1946.
I'm at 5,000.
This is a straight no contest, and I think the guy actually admitted in his letter that he bought from a liquor store.
I'm all right with 5,000.
Because he says we owed Southern money and didn't pay it, so then couldn't order from them. Started getting it elsewhere.
Okay.
Well, they could order from them, they just couldn't pay for it.
No, but started getting it elsewhere tells me it's the liquor store.
They couldn't pay the COD.
Well, what'd you say, Commissioner Fan? What was your fine?
It was 5,000.
5,000.
5,000.
1947.
2,000.
Accept.
2,000 accept.
1949 and 50.
What about 48?
We did that.
48.
No, that's one of
Flynn's.
That's one of Flynn's.
49 and 50, okay.
17.5. Accept.
No. Oh, right, okay. I was at cancel and bond, just because of their history over the last 2 years.
Cancel and bond?
I'll do 17. I'll accept it. Actually, I was thinking more like 20.
So I guess we're taking it 17.5, go.
Okay. 51 and 52.
Cancel and bond.
Withdraw charge 6 at council's request and cancel and bond.
53.
Letter of warning. Built since 1958.
I'll do a letter of warning if you want because of the financial hardship.
That's fine.
A letter of warning.
Yes.
1954.
What, 2,500?
I would accept, but can you add in the letter that the liquor store licenses in Chinatown is really big privilege and shouldn't be abused?
I actually was going to call them in to find out what's going on here. Can we have them come in?
Sure.
So I'll put this over to
1023.
All right, because this is a first for me.
I mean, those are two of the few disorderly type charges you can bring against a package store.
No, she's right. You're in the middle of Chinatown and you're getting a police focal point. I mean, come on.
19. Oh, is everybody good with putting him in?
Yeah.
Yeah.
1955.
500 is that?
It's, so we can put Flynn's cases over. We're not going to wait around for an hour.
Okay, so.
And what numbers are those?
So
What about 1959? We can do that.
That's his.
1959 is one of Mr. Flynn's cases. You want that over to 1023?
Yes.
Okay. 1960 and 61, also Mr. Flynn.
1023.
1923.
1023.
And then finally 48 and 65.
1023.
I will, once we get done here, I will send him an email. I have nothing else on the calendar. Chairman, do you have anything else?
No.
And we are.
We're done, and congratulations for Gary.